and there may be a settlement between the parties. The matter is referred to National Lok Adalat to be held in the month of December. Stop. Fix 8/1/2026 for report of the National Lok Adalat.
Obliged, Your Lordship. Grateful to.
Number 14 and 15.
My lord, I am appealing on the respondent claimant. My lord, landed advocate of the insurance company could not come today, my lord.
Not today.
Not today. And my lord, the regarding item 15, my lord, the number will be 66. Yes.
Okay, give, it will be rectified. I am making it not today.
My lord, the matter was already heard and was reserved for the judgment, my lord, on 24th of November 2025, my
Let
lord.
me see the record.
On
It came under wrong
24th,
heading,
it
my lord.
was
Let
fixed
me
for
let me
delivery
see
of
the record.
judgment. My lord.
রেকর্ডটা আছে? তাহলে অর্ডারটা এখানে রেকর্ড করে দিই, রেকর্ড করে লিখি, দিয়ে অর্ডার শিটটা আমার কাছে পাঠিয়ে দেবেন। আমি একটা ডেটটা বলে দিচ্ছি আর কি। Yes, record and order. Learned advocates for the parties are present. As the hearing of this matter is concluded and judgment is required to be delivered, let this matter appear on 2/12/2025 for judgment.
My lord. Grateful.
Grateful, my lord.
Number 17.
My lord, I am for the appellant, my lord.
এদিকে আসুন।
I am for the appellant.
Yes, yes.
For respondent insurance.
So matter is ready for hearing.
My lord, paper book.
Today is fixed for filing paper book, my lord. I prefer.
Paper books not yet filed.
No, my lord.
Anyway, file it. I'm keeping it in the month of January. Yes, record and order. Learned advocates for the parties are present. Learned advocates for the appellant press for time to file the paper books. Thus, the time to file paper books is extended till 8/1/2026.
Formal paper book.
Informal paper books is extended till 8/1/2026. As this matter relates to motor accident claim and may be settled through Lok Adalat, the matter is referred to National Lok Adalat to be held in the month of December. Fix 8/1/2026 for report of National Lok Adalat. You take instructions if your client is ready and willing to settle.
আমার নামটা শুধু
I'm grateful, my lord.
Item 18. Well, 18, I am for the petitioner minute. Well, it's a proceeding under NI Act, and I am praying for expeditious disposal of this matter, millet. Millet.
Okay, let me see the records.
Well, the case has been instituted in 2014. The plea was recorded sometimes, millet, in 2018. Thereafter, the evidence in chief was done in 2019. Cross-examination commenced. Thereafter, they have taken several times on which the cross-examination could not complete. Subsequently, they have refused to appear before the learned court, and the learned court was compelled to issue warrant of arrest against him. That execution is pending since 2022. Millet, the check amount is around 13 lakhs and odd, millet. I'm suffering for last 11 years.
So unless the accused is brought before the court, there is no scope for the court.
Millet,
case to be dismissed.
that is why, millet, I am seeking a direction from your lordship that if your lordship be kind enough to fix a date for within a certain period, the warrant is to be executed and the entire process is to be exercised. Unless there is a direction.
Is the next date fixed?
Millet, the next date fixed. Millet, it was in the month of July. Millet, the present update is not with me, millet. It was in the month of July.
No. ER of WA, when is the next date? ER of WA.
My lord, then can I come back tomorrow, my lord? I'll come back with that instructions, my lord.
Not today.
Lordship, I am for the petitioner. I am praying for her very short Passover, Lordship.
Item 19.
Yes, Lord.
Okay, short Passover.
Grateful.
My lord, I am for the appellant. In this case, my lord, kindly post of insurance company কোথায়? My lord, in this case, kindly, this is very simple.
No, this is application. Two applications are here.
Application. One is the from minor to major for appellants, and another is the deceased identity, Aadhaar card and PAN card. Aadhaar card, not Aadhaar card. At that time, Aadhaar card was not introduced. Voter ID card I was placed, and the Pradhan certificate. And let my lord kindly see the documents.
Can one to the key can one.
And page 6 of Can 1. Page 6, 7, 8, 9, exhibit A, B, C, D.
Page 6.
Yes, my lord. Page 6 of Can 1.
Yes.
My lord, kindly see A, annexure.
So that is the Aadhaar card, or this is the Aadhaar card of the victim. That is the widow of the victim.
No, widow and sons.
No, this page 6. Page 6 is the Aadhaar card of the widow.
Yes. That's 11, yes.
So for page 7, yes, it is Aadhaar card of the son.
Son. 4
Page
sons.
8. Yes, Aadhaar card of the son. Page 9, Aadhaar card of the son. Yes. Page 7, 8 and 9.
6, 7, 8, 9.
No, 6 is the widow.
What do we do? Yes, your honor. 7, 8, 9. Right.
Question is, you want the amendment with regard to respondent number 2, 3, 4, 2, 3 and 4.
2, 3, 4.
2, 3, 4.
2, 3, 4.
2, 3, 4 are to be recorded as measure.
Measure. Actually, there is a 5 also. That is Can 2. Aadhaar card I was
Separate.
placed.
Separate application.
Yes.
Yes, record and
No,
order.
my lord, I object to this.
Yes.
My lord, paper book কি ওখানে আছে? Paper book. My lord will kindly see the paper book once. This is a dismissal case. In this application Can 1, they have said that the this Abu Bakr Mukami, the children,
Yes.
they are the children of Hassan Ali Mukami. Name of the victim is,
No, are they parties before the trial court?
may I?
Yes.
The name of the victim is Abul Hassan Mukami,
Yes.
and they are the children of Hassan Ali Mukami. So how come, what's the use of bringing Hassan Ali Mukami's legal heirs into the picture? I don't understand. Number one. Number two, my lord, where is the legal heirship certificate? It's just a
Panchayat
pradhan.
certificate.
Yes, it's just a panchayat certificate. How can this prove that
So
they
you
are the
want to
legal
take
heirs?
instructions with regard to this matter? I can
No.
adjourn it.
No, there is no.
You want to file opposition?
I shall.
Okay.
My lord, one thing. My lord, kindly see order dated 19/9/24 in the order sheet. The whole matter will be disposed of. Matter, kindly see the order dated 19/9/24.
So there was a direction to file Aadhaar card of the deceased.
Aadhaar card and any other related documents on affidavit.
Affidavit. So did you
Yes.
file that?
Yes.
Aadhaar card?
Aadhaar card, no. At that
Aadhaar
time,
card
Aadhaar
of the
card was
deceased.
introduced. 2004, 2000 introduced on 2010. And that's
When
why.
did this person die? Prior to 2009?
Yes, yes, yes.
2004.
2004.
Oh, 2004.
So I have placed the
Anyway, if you want to file
voters.
objection, file. Learned advocates for the parties are present. Learned advocate for the opposite party insurance company prays for time to file the affidavit in opposition to Can 1 of 2024 and Can 2 of 2024. Such prayer is allowed. Let the affidavit in opposition be filed on or before 4/12/2024.
No, my lord will give me some more time because
Okay.
2004, now 2025, end.
Okay. 11.
Only 20 years have passed.
2025.
my lord,
11/12/2025.
my lord.
Reply, if any, by 18/12/2025. Let this matter appear on 2/1/2026.
2nd of January.
In the meantime, my lord,
Great.
copy may be served.
Yes, yes, I shall.
Sir, under the heading, my lord.
Under the same heading.
Grateful, my lord.
It is. Yes.
In this matter, I am for
the appellant.
I am for respondent and cross objector.
What application? Can 2?
Can 2 of 25
No.
is my application.
Can 2 of 24?
24 subsequently it has been
Disposed.
some mistake but they corrected by department. It will be 22 of 25.
Now your application is which one?
My application is on order 6 rule 17.
No. Can 2.
Can 2 of 24 it has been corrected by department. It will now 2 of 25.
In connection with the court.
So Can 2 is to be taken up for consideration.
Yes, Mr.
Yes.
220 হ্যাঁ ঠিক আছে ওটা ঠিক আছে হয়ে গেছে কারেকশন হয়ে গেছে yes my lord only name of the cross objectors or respondent the name was Nageshwar Sao. There is no kindly my lord kindly see the can 2 of 25 page number 4.
Can 2
My
of
lord kindly see the schedule page number 4. The name Nageshwar Sao mentioned in all over the cross objection bearing court number 48 of 2023 and also in the application bearing can of 1 of 23 will be changed as Nageshwar Sao.
Only H has to be added.
Yes, only H has been added.
Yes, record an order.
Also memo.
Learned advocates for the parties are present. This application is taken out for amendment of the cause title with regard to the name of the appellant in COT 48 of 2023. The applicant stroke appellant seeks to rectify the name of Nageshwar Shaw, NAGESWAR Shaw as NAGESHWAR. Stop. As the amendment sought for is formal in nature, the same is allowed. Let the name of Nageshwar Shaw be rectified as mentioned in schedule of Can 2 of 2025, both in Court 48 of 2023 as well as in FMA 3206 of 2016.
Memo of appeal.
Yes, yes.
Memo of appeal.
That is why I have mentioned
Yes, yes.
the department to carry out the amendment within a period of 2 weeks. Liberty to mention.
নাম্বার দিতে হবে না, আছে তো। মাঝে নাম্বার দিতে দিয়ে দিচ্ছি। হ্যাঁ, ওই দিয়ে দিচ্ছি।
আপনারটা কি বলে দেবো যে আপনি অসুস্থ মরে নেওয়ার জন্য ভাই কবে শুক্রবার দিন ফিক্স করে দিই না কোনো ফিক্স করবো না
24, Roshan, can you recollect that the last submission in this issue, and Lordship also please to direct that the if you have any Minimum Wages Act 2014 regarding income of the deceased. Lordship, I am very candid and fair submission.
What was the argument made by you?
Argument made by me. So Lordship, I am very candidly I am submitting this, Lordship, in the year of 2014. If I'll go by the for 2014 circular government minimum wages act notification, to that extent, I can press only 188 rupees. So 5,188 rupees. So in regarding income, I am not facing anything. Once 5,000 considered, I'm happy with that. But even then, Lordship, another two-fold pair people.
So 5,188 as per the minimum wages act.
Minimum wages act. So
And it is
5,000. So I am not with it. Because otherwise,
so that point you are not urging.
I am not urging. But Lordship, kindly see, Lordship also noted my submission. Apart from that, I have.
Okay, this can one. Okay, it's expeditious.
That is disposal. I could act anyway with that.
ঠিক আছে, এটা তো না, সেটা ঠিক আছে, তো হিয়ারিং করেছে আগের দিন। Oh, you argued this matter on the last occasion?
Yes, just yesterday. And Lordship also, I have said, Lordship also please to take, yes, not today. So come prepare with the minimum wages notification.
So on the basis of 5,000,
yes,
the tribunal proceeded. So you are not pressing that point. So what other points you are now urging?
Apart from that, Lordship, that is also not my ground of appeal also, the income. Another point is that, Lordship, first one is the Learned Tribunal did not consider the future prospect. In respect of the age of the deceased, the Learned Tribunal considered, Lordship, 53 years. No, right?
So it should be 10%.
10%. I'm a blessed Lordship, 10%. And Lordship, another is that, Lordship, kindly come to page 51. Paper.
Yes.
Just kindly come page number 51, last 3 lines.
51.
51.
Yes.
Last 3 lines.
Yes.
Lordship, kindly see, just start. In addition, Lordship, got it?
Yes.
In addition, that pensioners are entitled to get interest of 6% per annum with effect from the date of evidence of the PW1, that is 9th August 2029. So that should not be. So the Learned Tribunal ought to have granted awarded from the date of filing of the claim application till the date of realization. And the interest awarded from 2019, and it was up to that. So I am entitled to get interest from the date of filing of the claim application till 9/8/2019. Because after that, the award they have given that. So interest from the date of filing of the claim application till Lordship 8/8/2019. It's a fair calculation. From 9th they have given, so up to 8/8/2019.
So instead of date of filing, it is taken from date of evidence.
Lordship.
PW1.
Lordship. So also kindly dispose of the appeal subject to submission of Mr. Roy
Yes.
and
due to interest from the date of deposition of PDL only for several days has been taken by the claimants. That is your lawsuit discretionary power your lawsuit. Is up to your lawsuit.
other part I am not placing, that will be unaltered.
Yes, record an order. Learned advocates for the parties at present are learned advocates for the parties. The appellant before this court were the claimants in a motor accident claim case under section 166 of the Motor Vehicles Act 1988 and aggrieved by the judgment and award dated 26/3/2021 passed by learned additional district judge fast track second court Tomluk district Purbo Medinipur. Stop. Next para. The case of the appellant stroke claimants may be summed up thus. On 27/8/2014 at about 7:30 p.m. while the victim was standing extreme left side mud portion of Digha Nandakumar Road at Sri Krishnapur Mode. At that time, the offending vehicle being WB 26C/3092 Ambassador was coming from Bajkul side, proceeded towards Narghat side with very excessive speed, and when reached Sri Krishnapur Mode, the driver of the said vehicle could not control the said vehicle, which dashed, knocked and ran over the victim, and for which he was injured very grievously. Stop. The victim was taken to Irashal BPHC hospital, where the doctor declared him dead due to the said accidental injuries. Stop. The said accident took place due to rash and negligent driving of the driver of the offending vehicle being numbered WB 26C/3092, as the said driver was driving the said vehicle, endangering human life and safety. Stop. As a result of the accident, the victim sustained grievous injuries. Stop. It was also contended by the appellant claimants that the accident took place due to rash and negligent driving on the part of driver of the offending vehicle number WB 26C/3092, and the date of the accident, the victim was aged about 25 years and earning rupees 15,000 per month as expert work of brickfield. Stop. Pursuant to the institution of the case, notice was issued upon the opposite parties. The respondent number 1, National Insurance Company Limited, contested the case by filing written statement. Stop. Issues were framed, and upon considering the evidence adduced by the claimants, appellants, and upon hearing the parties, the learned trial court was pleased to dispose of the claim case by observing and directing as follows. এটা করে দেবেন কোর্ট page 52, ঠিক আছে, কোর্ট page 52, hence it is ordered. Next para. The appellant the appellant's claimants being aggrieved by the judgment and award passed by the learned trial court has come up with the instant appeal. Stop. Although different grounds were taken by the appellants in this appeal, but learned advocate for the appellant has confined his submission only with regard to future prospect not taken into consideration by the learned trial court and the quantum of interest awarded. Stop. Heard learned advocates for the appellant claimants and learned advocate for respondent number 1, National Insurance Company Limited. Peruse the materials on record. Learned advocates for the appellants submit that the learned trial court erred in not taking into consideration the future prospect of the victim, which ought to have been taken. Stop. It is further sustained. It is further submitted by the learned advocate that the learned trial judge erred in awarding interest from the date of evidence till the date of realization, stop, which ought to have been granted from the date of filing of the claim case till the date of realization. Learned advocate also submits that on the grounds submitted, the award passed by the learned trial court should be enhanced. Learned advocate appearing for the respondent number 1, National Insurance Company Limited, objects to the submission of the learned advocate for the appellant. Upon perusing the evidence adduced and upon hearing the learned advocate and considering the judicial decisions, this court is of the view that the future prospect of the victim ought to have been taken into consideration. Stop. As the victim was 53 years of age, the future prospect of 10% ought to have been added with the total yearly income. The total yearly income is assessed. The total yearly income is assessed by 60,000, and upon 1/3 deduction on the grounds of dependency, it comes to rupees 40,000. By taking future prospect of 10% into consideration, it comes to rupees 44,000. On rupees 44,000, the multiplier of 11 being applied, it comes to rupees 4,84,000. Yes, general damages awarded is 70,000.
That is given.
The general damages to be added is 70,000. Thus, the claimants, appellants, is entitled to rupees 5,54,000 as total compensation. Stop. Upon perusing the order passed by the learned trial court, it appears that although there is no findings of the learned court that due to delay caused by the learned advocates for the claimants, the interest is to be fixed from the date of the evidence, this court is unable to accept the decision of the learned trial court in awarding interest from the date of evidence of the claimants. And this court is of the view that interest ought to have been granted from the date of filing till the date of realization. Thus, this appeal stands disposed. The judgment and order dated 26/3/2021 passed by learned additional district judge, first track, second court, Tomluk, in MSC case number 31 of 2018 is modified to the extent that the appellant's claimants are entitled to a compensation of rupees 55,54,000. Stop. Thus, the respondent number insurance company shall pay rupees 5,54,000 along with interest at the rate of 6% per annum.
Already received some 5 lakhs.
Okay, just a minute. 6%. Learned advocates for thus the claimants appellants are entitled to receive rupees 5,54,000. The claimants appellants, stroke appellants, are entitled to receive rupees 5,54,000 as total compensation from along with interest at the rate of 6% per annum from the date of filing till date of realization. Stop. As it is submitted by the learned advocates that the claimants appellants have already received the awarded sum as directed by the learned trial court, let the balance amount be deposited. Yes.
Balance amount 44.
The balance amount which the claimants appellants is to receive from the respondent want insurance company be deposited before the
Figure 44,000.
amount of rupees 44,000 along with interest from the date of filing till date of evidence. Date of evidence being 9/8/2019 be deposited before the Registrar General within 4 weeks from date.
6 weeks. 6.
Okay, within 6 weeks from date, the claimants appellants are permitted to withdraw the deposit upon compliance of all necessary formalities.
The earlier interest loss is not awarded.
Yes.
5,10,000 that we have received without interest from the date of filing till the date of evidence. That is one of the ground.
Date of filing till
5,10,000 land have been awarded. So that amount is without interest from the date of filing till the date of evidence, 9/8/2029.
Okay. So the last portion take to bolu.
The balance amount of rupees 44,000 along with interest from the date of filing till the date of evidence being 9/8/2019 be deposited before the Registrar General within 6 weeks from date.
Further, interest at the rate of 6% per annum on rupees 5,10,000 be 5,10,000 from the date of filing till date of deposit till date of deposition of PW1, that is on 19/8/2019, be deposited before the Registrar General, High Court, Calcutta within a period of 6 weeks from date. Tarpore, the appellants claimants are permitted to withdraw the amount upon compliance of all the necessary formalities. Yes, this appeal stands disposed.
So kindly add one line that the award as passed by the learned tribunal that I have received.
Yes.
Award passed by the learned tribunal that I have received. Kindly record this line.
No, I have recorded that it is there. I have recorded your submission that the awarded sum has been paid in terms of the trial court order. That I have recorded.
দেখলেন কালকে আপনি আমার সঙ্গে রাগাইটা করলেন
সাবমিশন করতে আগে তোমার সঙ্গে
মতন নিয়ে নেবো আমি
তোমার সঙ্গে রাগারাগি হবে না, এমনি তো হবে,
আমি করবোই না কাজ।
আমি জানি তো।
I beg to appear not on behalf of the petitioner.
And I am for the Union of India.
Railway?
So,
Yes, including
whose
railway.
application is this? Can one?
So that was for stay. Your Lordship, on the last occasion, wanted Milord to hear out the writ petition or the appeal, whichever Milord way your lordship wants to Milord nomenclature it. Milord, there are two parts Milord to this writ petition. Milord, this is challenging an order directing us Milord to put in money which has already been paid.
Well, subject to your lordship's, my lord, I have not get any instruction as yet
Regarding?
regarding my lord, writ petition.
No, this application can one is taken up for consideration.
Now, Milord, the question is there, Milord, I'll tell you, Lordship, Milord, we have a steel plant somewhere, Milord, in Madhya Pradesh. Milord, the place is called, it's a weird name, Milord, you know, Deojhar to Kirodiman. My steel plant Milord is at Kirodiman, and this iron ore, which is Milord the raw material Milord from which is used for Milord that steel plant, it goes from Deojhar to Milord Kirodiman, and we are regular customers Milord of railway. Our raw materials are taken. The raw material Milord is iron ore. It is taken Milord from Deojhar and taken Milord to Kirodiman. Milord, we booked Milord 10 rakes Milord with the railways. We do that often. It happens Milord on a regular basis. Now, what happens is, once this consignment Milord left Deojhar, and in the middle Milord, somewhere in Kharagpur, there was some problem Milord with the railway tracks. The law is that they will take it Milord from the shortest possible route. Now, this shortest possible route Milord is fixed Milord by the railways. Railways Milord, I see Milord, by the consignment left Deojhar, but it got stuck somewhere in the middle, and it was not moving Milord from that place. So we wrote a letter Milord to the railway saying what's happening, please let us know. Railways informed us that there is a problem with the tracks, their problem with the tracks, and they cannot take it forward, and it will take a long time. Now, Milord, in Kirodimal, my plant almost came to a standstill because Milord, there was no raw material. So at that point of time, I told them, please take the raw material from wherever you want to, and whatever is required, I will have to pay in terms of law. Now, what happens here is they took it Milord from the longest possible route, not the shortest, the longest possible route, and put the money on me. Milord, if they had made some sort of Milord, even thought about it, we would have told them that there were shorter routes available. They did not do that. They took it on their own from the longest route possible.
On your representation,
yes, Milord, there were shorter routes. There were shorter routes, but they took it from the longest route possible.
The decision they took is on your
yes,
representation.
Yes, Milord, that is because of their own wrong. Because Milord, the railway tracks were not Milord were not usable. That is why Milord they said that. And Milord, I am in a situation where of extreme undue influence, because my entire Milord, the plant Milord is in a standstill, and it's a huge Milord steel plant. So I had to relent to whatever Milord they wanted us to relent to. Now, very weirdly, Milord, what happens here is they demand 7 crores and not from me. They admit that I have paid that 7 crores. So my writ petition or appeal, in whichever way your lordship looks at it, it has two parts. One is the court directs me to pay again 7 crores. Again, the 7 crores they admit I've already paid. He again says pay 7 crores.
What is the ground for arriving at this decision?
No, there is no ground. Your lordship sees.
There is a judgment. Kindly see the judgment. It's a
No, the order under challenge.
Yes, kindly turns to the impugned order, Milord.
Page?
It's with the memorandum of appeal, Milord. And it's also at, yes, it's with the memorandum of appeal. Kindly have a look at page 14.
Page 14.
Yes, Milord.
Yes.
Your lordship will find at paragraph 7.
Yes.
That's the ordering portion. And why, Milord, this has been granted, kindly have a look at, I'll take your lordship to the entire, but seize paragraph 13. Or rather page 13, Milord, I'm sorry. Milord, for sake of continuation, kindly takes up page 12 bottom. Paragraph 6.3.2. Milord, there are the other paragraphs will also be very important, but for the moment, Milord takes this up. The complainant pleaded that while their letter to the chief operations manager, they requested for stopping the movement of rakes through the alternative longest route. It was also pleaded that on 22nd of August 2007, they again requested the respondent for movement of the rakes. Milord, kindly marks this. This becomes very important. When we found out that they were taking, Milord, the consignment from the longest possible route, we wrote to them that please do not do that. Please take it
So
from
this were before the tribunal.
before the tribunal. Before the railways, we wrote to
Before
them.
the authority as well as before the
Yes,
tribunal.
Milord. Yes, Milord. This is all produced before the tribunal. And this is the finding. It was also pleaded that on 22nd of August 2007, they again requested the respondent for movement of the rakes through a shorter route. Marks this. But nowhere are the copies of these letters duty acknowledged by the respondent are available on record anywhere. Milord, these are admitted documents. Repeatedly quoting these two letters without any evidence that these two letters were duly acknowledged by the respondent amounts to misleading the court. It has also been stated that though the normal route was restored at 6:20 a.m. on 23rd of August 2007, the respondent dispatched these three rakes even on 23rd of August 2007. Kindly marks the malafide. This is where I am on, Milord, before your lordship. In reply to this, the senior divisional commercial manager in his affidavit stated that there was a breach on the main line and the gravity of the said breach was very serious in nature due to washing out of the line. There was no certainty regarding the restoration of the said line. Though the said line was restored on 23rd August 2007, there was heavy speed restriction and the movement was on trial basis. Marks this. So it wasn't, Milord, that the shortest route was not available. Apart from this, the program for the movement of the three rakes had already been chalked out prior to 23rd August, and accordingly, the program was carried out in order to avoid the disruption of the movement of the traffic. The movement of the rakes are undertaken through the operational program basis, and once such a program is approved, the railway cannot suddenly revert back, as this could have imperiled the movement of the goods traffic, and the entire operational plans would have gotten disrupted. So it's for their own benefit. Milord, it's not for my benefit. It is for their benefit that, Milord, they took it from another route. The shortest route was available to them. They themselves decided, Milord, that this will harm them. That is why, Milord, this was, Milord, undertaken, Milord, by the railways. Then sees, and for this, I am being penalized. Kindly sees, it is crystal clear that after a breach at the shortest route due to a natural calamity, as the complainant did not have adequate stock of iron ore in the plant in Kirodimal Nagar, they requested Chief Operations Manager to move their rakes via an alternative route. I did. Because at that point of time, Milord, I did not have, the shortest route was not available. They undertook to pay the necessary freight charges. They did not specify the alternative route for movement of the rakes. It's not for me to specify. They did not specify the alternative route for movement of their rakes. The choice of alternative route was left to the Southeastern Railway. Hence, Southeastern Railway chose a route which in their view was operationally convenient and fastest at that point of time. The route, suppose I'm going from Calcutta to Delhi, I suddenly say that, no, I don't want to go via Goa. I will go first to Madras, then I will go to Bombay, and then I will go to Delhi. And for all this, Milord, who has to pay? I have to pay. And this they put on, Milord, on me, saying for operational reasons.
You see, your contract will come into operation, whatever were the
My Lord,
terms.
I completely bow down.
There is a specific provision.
There is a provision in law as well. I'll show your lordship that.
Whatever
They
is
will
there in your contract and in the law.
Absolutely. My Lord, I'll show your lordship that. Because they can't put this upon me. My Lord, forgets about any law or contract, my Lord, for the time being, with a lot of respect. If your lordship sees, my Lord, by logic, my Lord, I can go from X to Y in one route. I choose not to do it. Why? Because I have a problem. I say that I will not take the shortest possible alternative route, but I will take a longer route. And because I have not specified the route, that is why the entire money, my Lord, is put on me. Looks to it, my Lord, in my respectful submission, my Lord, for the moment, doesn't even look into law.
While in the original contract, that route was mentioned.
Yes, my Lord.
So thereafter, there is a variation.
My Lord.
Now, question is, at the time of entering into the contract, is there any provision that in the case of subsequent exigency?
That's law. And the law provides for, my Lord, that it has to be done in a particular way.
Yes.
And that was not done. I'll show you a lot. It's
Exigency or
absolutely.
otherwise.
Milord, I am saying you don't have to get into that because you yourself say that that route was available on that day. Then, Milord, Southeastern Railway has correctly raised the undercharges and the same should be duly paid by the applicant. Milord, kindly then comes down. The total undercharges amount raised by the respondent railway was rupees 7 crores 14 lakhs 61,000, out of which the claimant already paid 3 crores 11 lakhs. Therefore, the outstanding dues remains 4 crores 3 lakhs. Now, this, my learned senior friend, needs to take instruction immediately before your lordship that this 4 crores, Milord, is also paid, and they acknowledge that. Kindly have a look at the acknowledgement, Milord.
This is the findings of the facts, okay?
Yes, Milord.
So regarding
That's the ordering portion.
No, this operative portion. This is the findings on the facts.
Yes, Milord.
You are challenging the findings of the facts.
Absolutely.
The basis of the material.
Milord, I am challenging on 2 grounds.
Yes.
First of all, Milord, the entire amount of 7 crores which has again been directed me to be paid is already paid.
Yes.
So they could not have directed me to pay again.
Yes. No, that's 7 crore. That is the contractual amount.
I have paid that. That is not the contractual amount.
That isn't.
That is the amount that they wanted from me after Milord taking it from the longest route.
So the first is the
Contractual amount has to be paid.
Yes.
Has been paid.
In case of exigency on their proposal, you accepted.
My lord.
7 crores. So
My
this is the factual aspect.
Factual aspect.
Yes.
That 7 crores is already paid to them.
7 crores is already
Paid. Kindly looks to Milord their own admission.
The findings is otherwise.
Exactly.
So this is the findings of fact which you are challenging in this
My lord.
petition.
My lord. So that 7 crores could not have been directed to be paid again. Kindly turns to Milord page 191.
Although there is a direction of 50%, not a single
amount to be paid from here. They have themselves Milord quantified the amount. Looks to 191 in the stay application. That's a part, Milord, of his written statement, not mine.
Page 121.
Yes, 191.
191.
191. So if my learned senior friend can take instruction and Milord by one word, Milord, this can be Milord taken care of.
This is a matter of record also. Let him take instructions both.
Yes.
I will file opposition of the stay application.
No, let him file opposition, whatever he wants
Let him
to.
bring it on the record.
Yes, stays the operation of the order now. That operation of the order needs to be stayed. Kindly sees Milord paragraph 36, paragraph 16.
Without opposition, it cannot be stayed.
Just.
Bah.
Yes. Paragraph
16. 16.
That is page 191.
Yes, Milord. Page 191 is a part of the written statement.
Yes.
But Milord sees paragraph 16.
Yes.
Milord sees the last line. But subsequently, Lordship, kindly got that, Milord?
Yes.
But subsequently, the undercharge raised by the chief's goods supervisor Deojhar was wrong, whereby the audit raised an additional amount of an undercharge amounting to 92,67,000, which is still lying outstanding against the complainant.
Yes.
And then kindly turns to Milord, paragraph 18. Your Lordship need not at the present moment. Kindly turns to paragraph 20. At page Milord 193.
Yes.
That in reference to paragraph 18, it is submitted by the deputy director, detected the wrong calculation of the undercharge on the basis of distance covered by the 10 rakes dispatched from Deojhar. Hence, he rectified the error committed by the chief goods supervisor Deojhar and recalculated the undercharge, which comes to an amount of 4 crores 87 lakhs 75,450 instead of such and such. So the differential amount is still lying outstanding.
This is their stand.
Their stand. When the letter was received by the deputy director, when the letter was received from the deputy director, the demand was made in the counter affidavit filed on behalf of the respondent. Then kindly turns to 195. In tranches, this has been paid, and the lastly, Milord, comes to.
No, your challenges with before the claims tribunal, before the tribunal was their claim, not with regard to that original claim?
No.
Because that you accepted.
Absolutely.
So only with
Absolutely.
regard to the quantum. what you're
Absolutely,
telling.
Vinod. I bow down. Bow down. This entire amount, which of 7 crores 21 lakh 17,000, which was also the additional charge, but the initial contract I have to pay. There is no question about it.
Additional charge was accepted by you without protest.
With protest and
No, at
was
the
never
initial-
accepted.
At the initial stage.
My lord, was never accepted. We said that you can't take it from the longest route. And they acknowledged, my lord, that they have the shortest route was available to them. Today, my lord, if I can go from Calcutta to Delhi via Goa, my lord, if there is something at Goa, my lord, I understand.
Now, what is their stand is whatever they are charged, whatever they charge from you, that is by mistake. That is a
Not just
that
mistake,
is-
the calculation was under
that
scrutiny.
is the calculation.
Yes, but they forget, my lord, that whether they can even charge me for taking it by the longest route. They forget that.
But anyway, you accepted it.
I did not accept, my lord. I've written letters, they're on record, and your lordship will find me. And then kindly sees this
Their
part.
only stand is whatever they are accepted is a lesser amount. Arrived.
Not the lesser amount. This 7 crore is the amount they wanted from me.
Yes. But
This is not the lesser amount.
what does this paragraph say? Paragraph 16.
Paragraph 16, my lord.
You see, they were undercharged.
Yes. Then they, which is still lying outstanding against the complainant, 92 lakhs.
Additional amount of undercharge.
Yes.
So
Lord,
according to
even
them-
what happened was, initially there is a payment, then there is another, my lord, initially there was a, my lord, a demand, then they again
Part
revised
payment.
that. Yes, my lord. The initial demand was initially paid. Then the dispute starts from, my lord, when they started charging me additional. There the dispute starts. Then they made a demand again, which was wrong according to them. Then they again, my lord, rectified it. We, my lord, paid the entire amount that they wanted without prejudice to our rights and contentions. That they acknowledge at paragraph 25. Kindly have a look at 195.
Yes.
Under the above facts, you know, the last paragraph of 26, the last line of 26.
Yes.
Under the above facts, it is clearly evident that the claimant, being fully convinced regarding his liability towards the demand raised by the respondents, he made a petition during the course of hearing, praying therein to allow him to deposit 7 crores 2117, which was the balance outstanding according to the complainant. High Court order to that. And in terms of this, my lord, we put in the money with them. The learned tribunal forgot about that completely. So my lord, today my challenge is twofold. One is the correctness of 7 crores, which I want to, my lord, establish before your lordship that it is not worth it. The second part is, my lord, that the tribunal forgot that this 7 crores is already paid by me.
Because you see, this court, appellate court, has to confine itself to your claim.
Completely.
The subject matter of the claim before the tribunal.
Absolutely.
Whatever you have claimed there,
I bow down to it.
this court has to confine
I
within that.
completely bow down. So this claim, my lord, kindly appreciates, this claim of 7 crores is already paid by me.
Right.
So the tribunal could not have asked me to pay again the 7 crores. So they will today, my lord, get 14 crores if this order stands. That can't happen. This is one part which I will pray before your lordship to state immediately. The second part is whether, my lord, this 7 crores which they have my lord, demanded, whether that is correct or not, that, my lord, my learned senior friend can take instructions. I am not on that.
Whatever they demanded, that was also the subject matter.
Yes,
the
my
claim
lord.
tribunal.
Yes, my lord. So the
Earlier, did you make any representation to refund that amount?
No, I didn't. It was there, my lord, the High Court relegated me to the tribunal. There was, my lord, we filed a writ petition before the Odisha court.
Yes.
The High Court said, no, you can't do that. You have to go to the Railways Rates Tribunal. So we went there. Oh, wherever. So we went there and then the adjudications happened. So with respect to jurisdiction, there is no problem at all. My claim, my lord, basically their claim, I, my lord, challenged it. So one part is that you could not have asked me to put in again the 7 crores because I've already paid you the 7 crores without prejudice to my rights and contentions. So this needs to be stayed immediately. And the second part is, my lord, whether that claim is correct or not. That's the second part for which he can take instructions. I don't have a problem at all. Yes. Kindly have a look to 117, my lord. I'll show your lordship that the money is paid. Turns to 117. এটা চেন্নাইয়ের না উড়িষ্যা চেন্নাই বলছো কেন উড়িষ্যা ঠিকই তো বলেছি
উড়িষ্যা বলেছিল চেন্নাই যেতে
petitioner is direct my lord Kali got it plot
উড়িষ্যা চেন্নাই যেতে বলে
Directed to
petitioner is directed to deposit the outstanding amount of such and such towards demand for license fee in respect of Deojhar to Borshuan and for undercharges without prejudice to its rights and contentions.
the present writ petition.
And this was paid, my lord. Your lordship, my lord, looks to the tribunal's order, which your lordship will find, my lord, at page 184.
So this order was complied with.
Yes. So they could not have asked me to pay again. 184, the tribunal records that we put in the money. 184. So this part of the order, my lord, kindly stays immediately. With respect to the other part, my lord, we shall, my lord, make submissions whenever my learned senior friend is ready.
So that is last page of the tribunal's order.
Yes, my lord. No, 184 order. Yes, yes. I bow down, my lord.
Yes. 4 crore 3,61,378.
Yes. This part of the order, my lord, kindly stays immediate. And satisfies my lord's self, my lord, that at page 184, this amount has been paid to them.
তখন বলবি
হয়ে গেছে আবার কি বলবি
আবার পড়িয়ে দিই অর্ডারটা তাহলে তো
হ্যাঁ
আরেকবার অর্ডারটা পড়িয়ে দিই
সে তুমি ইনস্ট্রাকশন নিয়ে এসো তারপর তুমি হাজারবার পড়ো
ডিসমিস কর যদি ক্লেম কি করে রিকভারি
correct absolutely appearing for the respondent submitted that the amount ordered by the Odisha High Court has been paid. Railways, my lord, is state. They should have, my lord, pointed it out that this was wrong. They are, my lord, the model landlords. They are not litigants. They should be, my lord, they are at a higher pedestal than a private litigant.
I am repeated page 13.
Page?
Kindly see, page 13.
1-3.
1-3.
Of the order?
Yes, impugned order. It is crystal clear that after a breach in the shortest route due to a natural calamity, kindly see it's a natural calamity.
Yes.
As the complainant did not have adequate stock of iron ore in the plant of Kirodimal Nagar, they requested Chief Operations Manager to move their rakes. They requested Chief Operation Manager to move their rakes an alternative route. It's their request. They undertook pay the necessary freight charges. Kindly do. The choice of alternative route was left to Southeastern Railway. Hence, Southeastern Railway chose a route which in their view was operationally convenient and first.
My learned senior friend is on merits. I am not on merits today. I will show your lordship. He needs to only tell your lordship whether he has the 7 crores or not. Nothing beyond that. These all merits, I haven't even shown your lordship 5%. I'll show everything to your lordship. This 7 crores he has. He can't have 14 crores.
If it is not, it is not state. My learned friend will not face any difficulties. Kindly give an opportunity of filing opposition. Of
Yes, record an order. Learned advocate for the appellant and learned advocate for the respondents are present. This appeal is directed against judgment and order dated 21/10/2024 passed by the Learned Railway Claims Tribunal Kolkata bench in OA within bracket 3 stroke KOL stroke 01 stroke 2017. The learned advocates for
No,
the
you have one, that's fine.
yes.
So any day your lordship please fixes it, but in the meantime kindly stays this.
Any day anyway.
Yes.
Learned advocate for the appellant submits that the appellant, although have paid the amount of rupees 7 crore 14 lakh 61,378 to the respondent railway authority, but the learned tribunal erred in directing payment to the respondent railway authority amount of rupees 4 crore 403,61,378 with a simple interest at the rate of 8% per annum from the date these were due to be paid. Stop. Along with the appeal, the appellants have also filed an application for stay. Learned advocate for the respondent submits that as it is necessary to take instructions as to whether the amount of rupees 7 crore 14 lakh 61,378 is already paid, it is necessary to file an affidavit in opposition. Thus, the respondents are granted liberty to file affidavit in opposition
of the stay application.
Of the application for stay.
6 weeks, man.
Within on or before 24/12.
24 December.
Yes, something more.
Extend.
Okay. On or before
24th of January.
9/1/2026. Reply, if any, by 16/1/2026. 2 weeks time. No, 16 means 1 week's time.
My lord, we'll do it.
Let this matter appear on 18/1/2026 at 2 p.m. Pending hearing of this application, there shall be a stay of the judgment and order dated 21/10/2024 passed by the learned Railway Claims Tribunal Kolkata bench in OA 3 stroke KOL stroke 01 2017 till
18th.
Yes.
Till 18th
Till
January.
30
till 31/2026, 30th January.
My lord, one prayer, my lord has granted me time till 16th. 16th is a Friday. Could it be 19th only, my lord? 19th then.
The affidavit in reply by 19th.
19 January.
Or matter apply.
Or 20th you want?
Yes.
Affidavit in reply যেটা আমি 16 করেছিলাম ওটা 20 দিন 20/1/2026.
Or matter will appear.
Let this matter appear on 27/1/2026 at 2 p.m. The interim order will continue to 30th of January.
That's all. My lord.
Or any
Deeply
further
appreciated.
order, which is
Yes, my lord. Any further
30th
order.
January 2026 or till further orders, whichever is earlier.
Yes.
My lord.
Not grateful.
Deeply obliged, my lord.
আমি দিয়ে দিয়েছি
I am for the claimant's appellants.
I am for the respondent insurance company.
My lord, delay, my lord, delay of 120 days. Delay may be condoned, my lord, I expect. Affidavit of service.
Yes, record an order. Yes, how many days delay?
120.
Yes, learned advocates for the parties are present. Heard learned advocates for the parties. This application, CAN 1 of 2025, which is for condonation of delay, is taken up for consideration. The appellant in the said application has prayed for condonation of delay of 120 days in filing this appeal. Upon hearing the learned advocates and upon perusing the petition, it appears that the appellant has shown sufficient grounds for condoning the delay. Thus, the delay in filing the appeal is condoned. The CAN 1 of 2025 is disposed and the appeal is admitted. Stop. As it is an appeal in a motor accident claims case, and that the matter may be settled, the matter is referred to National Lok Adalat to be held in the month of December. Let this matter appear on 8/1/2026 for report of National Lok
My
Adalat.
lord, kindly make it 8/12. 8, why, my lord? I have already proposed him, my lord.
Yes.
Let this matter can be settled.
Yes. So
let him
okay.
take instruction.
No.
Let him take instruction.
Question is, in the instruction, whatever is the instruction, whatever is will be the settlement, it will be filed before the National Lok Adalat to be held on 12th. Achha, let this matter appear on. Actually, I can keep the matter on 16th, but at that time, this bench will not be sitting.
Yes.
That is why I have kept it on 8/1/2026.
8/1.
Because last 2 weeks, this bench will not sit. That is
My
why I kept it on 8/1/2026.
My lord.
Twenty-seven, my lord, I am for the appellant insurance company. There is an application for stay of verdicts.
You have deposited the statutory amount.
My lord.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award passed by learned additional district judge, Fast Track First Court, Barakpur, North 24 Parganas, in MSC case number 55 of 2015 for a period of 5 weeks. Stop. The appellant's insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing till the date of deposit within this period of 5 weeks. Stop. In the event the entire awarded sum, within the period of 5, the appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within the period of 5 weeks. Stop. In the event the amount is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
I'm grateful, madam.
Okay.
Okay, not today.
My lord, I am for the appellant insurance company. My lord, in terms of last order, we have already deposited the entire amount. The order was 20th June 2025. And my lord, I am filing the affidavit of service and the copy of the my lord, the Tolobana also there. My lord, this is a very paper book is there also, my lord. A very short point is involved here. And my lord, in page.
Where is the paper books?
Paper will also kindly see the paper.
This delay is condoned.
Yes, my lord.
You have deposited the entire awarded sum.
Yes, my lord. I have already given the copy of the challan. And my lord, very short point is involved.
Yeah, paper books.
Page 55 of the paper book, my lord. There is, my lord, page 55. There, my lord, the grounds have taken. The driving license was seized, but the validity of the driving license was not confirmed. And the, my lord, several adjournment they have taken. That's why the interest point to be taken. But the last is, my lord, we can pay and recover, my lord. So we can take it, lordship may kindly dispose of this matter. Very short point is involved. We can pay and recover.
No, was the order of the trial court involved that condition, pay and recover?
No.
No, my lord.
So regarding that, you see, I have also pronounced a judgment.
Yes.
Under what conditions you can recover?
Lordship, judgment is there.
There is an unreported judgment.
Yes.
I have delivered.
Coordinate bench judgment, High Court judgment.
Yeah, High Court judgment.
Din talo. Active. Lordship, subject to the Mr. Chakravarti's appellant, subject to I have no cross objection. Only they are paying only that liberty to pay and recover.
No, question is in that, on that issue, I have also delivered a judgment.
Lordship.
So I think it's better I give you that copy.
Lordship.
Probably, anyway, I shall give you the name of that. So that you can.
Lordship, only this is the payer. I have no objection if Lordship will direct the pay and recover. So Lordship kindly disposed of what judgment may be reserved.
Question means I have to set aside the order of the trial court.
Not set aside, Lordship.
No, the pay and recover means what? That direction has to be imposed.
No, Lordship, there is no direction. There is only direction upon the insurance company to pay. Now they prefer an appeal. We are ready to pay, but liberty to recovery. So that only that extent they are asking for that.
Anyway, I'm keeping it tomorrow. I shall give you the copy of the judgment tomorrow. Okay. So you consider that, and this one. Thereafter, you make your submissions.
Lordship.
So not today, Lordship.
Yes, I'm making it just not today.
Just one line is a paperwork file kept with the record and not today.
Yes, learned advocates for the parties are present. Let the paper books file be kept with the record. Let this matter appear under the same heading on
tomorrow.
28.
28. Day after tomorrow.
Yeah.
28. 11/2025.
That's Friday.
A few matters will be there, so I can take it up.
Lordship, we have also deposited the copy of that challan also there. We have filed.
Let the copy of the challan deposited be kept with the record.
Lordship.
Lordship, Friday after 12, Lordship will take an hour.
Prior to that, I can take it up.
Lordship. As your Lordship.
I shall give that copy of the judgment for considering.
That judgment Reliance versus Niyati Kumari?
Probably.
Then, the thick judgment, is quite a
probably with regard to the driving license and recovery, I have gave some of the.
Future prospect was adjusted, was it that?
Probably that near some that Kumari, that near the Kumari. So
in that matter, your Lordship, after considering the entire facts,
they did not give the right to recover.
Yes. But I have given the reasons.
My lord has given the reasons.
Yes. So let your learned friend consider that Thereafter, if you can suggest something else, I can see.
Lordship.
What is the case number?
Milord, I remember the cause title. It is, Milord, your Lordship will grant me 2 minutes, Milord. I'll give
Okay,
the case
Niyati
number.
Kumari versus
Reliance versus, Milord, Reliance General Insurance Company Limited versus Niyati Kumari and others.
Right.
Lordship. Milord, I'll give the
And the
reference.
same heading, Lordship.
Yes.
But therefore, tomorrow matter will have the same heading, Lordship.
Same heading, same.
I'm given.
Number 30, I am here.
Action.
30 is my application for stay, my lord. I have deposited 25,000. This is the copy of the challan, my lord. I'm praying for stay,
Yes.
interim stay.
Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 22nd May 2025, passed by Learned Additional District Judge, Second Court, Shuri Birbhum, in MSC case number 174 of 2013 for a period of 5 weeks. Stop. Learned, the appellant insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing till realization, excluding the statutory amount within the period of 5 weeks. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
My lord, this amount may be invested in a short-term renewable.
The Registrar General is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time.
My lord, grateful, my lord.
That's a passover matter, item number 90.
Yes, call the passover matter. No, pending.
So the proceeding under section 138. So the check amount is, allegedly check amount is 16 lakhs. Now, Lordship, the learned magistrate, Lordship, the passed an order directing, Lordship, the imposing, Lordship, the 6 months punishment along with, Lordship, the check amount and 20 check amount 16 lakh, 27 lakh is fine. I preferred appeal, Lordship, the 20% of the check amount, Lordship, the appeal court, learned appeal court had directed to pay. I have paid. Now, Lordship, the appeal has been dismissed.
Okay, 20% you were directed to pay.
Direct to pay. I have already paid 20%.
At the time of admission of the appeal.
Admission of the appeal. Subsequently, that is has been directed to be adjusted. And challenging both the order, I have come before your Lordship. Lordship, the first ground of this, that kindly come to the order, page 23. That is the order of the Learned Judicial Magistrate First Class, Baharampur.
Yes.
Lordship, I'm just placing the fact. Fact is, Lordship, the check, the case of the complainant, the check was issued in favor of the father of the complainant. Now, check, ultimately in the cross-examination held, the check was, Lordship, the blank check. Now, blank check, father invested, according to them, father invested cash of rupees 16 lakh, in the 16 lakh 80,000 in the business. 80,000, Lordship, this present petitioners accused has refunded back. 16,000 did not, 16 lakh did not. So after the demise of the father, the son, Lordship, put the check into the concerned bank. Check has been bounced. So also this matter is required to be heard. Kindly come to page 23.
Yes.
The complainant and the accused both are the permanent resident of the same area, and the accused has a business of supplying coal to various brick fields. The complainant being an unemployed youth, his father was very much anxious about his employment and wanted to engage him in a business. The father of the complainant retired by that time, and he had sufficient fund to provide for his son. The accused being a family friend of the father of the complainant and has a familial terms with them, and the accused gave a proposal to start a partnership business of supply coal of various big field with the complainant. The father of the complainant agreed to such proposal, and the accused took rupees 16 lakh to 80,000 from the complainant during the period 2000 March 2014 to 20th June 2014. Let's say within, that is 3 months, with an assurance to start his partnership business, but in spite of repeated reminders, accused did not show any willingness to start the partnership business. In the meantime, father of the complainant died in 11th July 2014, and the complainant asked the accused to refund the amount because the complainant had information that accused has already started the business of supply of coal to various bricks field, and with the money keeping the complainant in the darkness. Accused killed time by this that the excuses, and ultimately the complainant could recover rupees 80,000 from the accused on different occasion. At last, the accused issued a check of rupees 16th lakh on 30th May 2015 in favor of the complainant by check number such and such, ICICI Bank, Baharampur, Kesanagar, Panchanantala, POPS, Baharampur, Murshidabad, for repayment of the money he owed to the complainant. The said check was represented by the complainant, presented by the complainant before the bank, namely Bank of Baroda, Baharampur branch, for encashment on 15th May 2015, but the said check was returned dishonored with the endorsement fund insufficient. Complainant thereafter issued a demand notice on 22nd May 2015 through the advocate such and such by the registered post demanding payment of the check amount. The accused received the demand notice on 28th May 2015, which was apparent from the endorsement of the wife Selina Bibi on the acknowledgement card, but the accused did not make any payment in terms of the said notice. Accordingly, complainant claimed the accused has committed offense. Lordship, this was the story. Now, Lordship, we raised a point that the presumption of section 139 could not be established, that his father has deposited 16th lakh in favor of the Lordship, the accused. The accused case is the accused admittedly received 80,000, and 80,000 has been paid. And when the 80,000 was paid, Lordship, the accused, Lordship, the hand over a, Lordship, as a security, accused hand over a blank check. Now, when the 80,000 Lordship refund, the father of the complainant assured that the blank check will be Lordship, the delivered. But when the father expired, Lordship, the blank check has been used as 16th lakh. Lordship, this is the case, Lordship. So, Lordship, the LCR is required. So, Lordship, kindly I am praying for stay of the operation of the proceeding pending before the learned court below. And in the meantime, Lordship, may I permit to serve the notice upon the opposite parties.
Yes, take down. Learned advocates for the petitioner is present. Our learned advocates for the petitioner. This application and this revisional application is directed against judgment and order dated 4/9/2025 passed by learned additional sessions judge, 3rd Court, Barhampur, Murshidabad, in criminal appeal number 10 of 2023, by which the learned judge confirm the impugned judgment and order dated 29/9/2023 passed by the learned judicial magistrate, Third Court, Barhampur, Murshidabad, in CR case number 22 within bracket 01 stroke 2015 under section 138 of the Negotiable Instruments Act. Learned advocate for the petitioner submits that the complainant has not been able to establish before the learned trial court that there was an enforceable trait due to which the check was issued. It is further submitted by the learned advocate for the learned advocate that from the cross-examination itself, it has come that the check issued was a blank check. It is also submitted that the presumption of law under section 139 and 118 of the Negotiable Instrument Act will not be in favor of the complainant in the facts and circumstances of the case. Upon hearing the learned advocates and considering the facts of the case, and that the petitioner, have you already deposited 20%?
20%, 5,53,000.
Already deposited rupees 5 lakh.
5,53,600.
53,600 before the learned appellate court. In the interest of justice, there should be stay of the judgment and order dated 29/9/2023 passed by the learned judicial magistrate, Third Court, Barhampur, Murshidabad, in CR case number 22 within bracket 01 stroke 2015 for a limited period till the respondents appear and contest the case. Stop. Let notice be issued upon the respondents within 1 week. An affidavit of service be filed. Let this matter appear before the regular bench on 22/12/2025. Pending hearing of this application, there shall be a stay of the judgment and order dated 29/9/2023 passed by the learned judicial magistrate, Third Court, Barhampur, Murshidabad, in CR case number 22 within bracket 01 stroke 2015 for a period of 6 weeks from date or till further orders, whichever is earlier.
Lordship, kindly come to the impugned order, that is the passed by the learned additional session judge, Third Court, Bahrampur.
Yes.
Lordship, kindly direct the department to correct this date of the order.
Okay. The impugned order, what is the date?
4th September 23, it will be 25. Because learned
let the relevant records of the impugned judgment and order passed by the appellate court be sent for necessary rectification and correction of the date of delivery of judgment, which ought to be 4/9/2025 but wrongly marked as 4/9/2023.
Plus 25. Yes, it will be 25. It has been recorded as 23.
But in my observation, I have recorded as 4/9/2023. What is your cause title?
Cost title I have
আপনি দাঁড়ান আপনি কেন
cost title আমি লিখেছি correction করে দেবো।
Aggrieved by the
Correction করেছি আমি
the
জজের কোর্টে
petitioner
25
being this appeal is directed against judgment and order dated 4/9/2025, wrongly recorded as 4/9/2020. The rest I have corrected because I am staying the operation of the order passed by the magistrate.
Lordship.
That is correct.
Yes, because learned magistrate's order is also 23. It
That's
cannot be 23. It will be 25.
No, I have recorded that order passed by the learned magistrate, Hard Court, Baharampur, in CR case number
29 September 23.
Yes, that I have recorded.
Yes. It is also recorded that 4th September 23. That cannot be. It will be 25. Appeal court's order.
No, appeal court's order, definitely there is a mistake.
Yes.
Okay, but there is no mistake with
In the yes, in the judgment of the learned magistrate's court, Lordship, there is
It's
no
correct,
mistake.
29/9/2023.
29
That is correct.
Correct.
Okay.
Then পড়বে। করা যায় না, যে জজ অর্ডার দিয়েছে তাকেই কাটা। Great. এই
Not today. Not 32. 32. Okay, not this week.
I'm for the appellant, insurance company, Lordship. I have served upon the opposite parties, Lordship.
My lord, I am appealing for the respondent number 2.
Lordship, can 2 is for a delay petition, condonation of delay petition.
Yes.
And can 1 is a stay petition, Lordship. There is a delay of 115 days in preferring this appeal. It was filed with a true copy, but the certified copy was obtained later. And Lordship, I have already...
2 is the condonation of delay. How many
Yes,
days?
115 days, Lordship. The case is filed with the true copy within time, but the certified copy was obtained later on.
You obtain leave to file this case without certified copy.
No, with true copy it was filed. Normally in claim
Normally,
cases,
leave is obtained for filing appeal without certified copies.
no,
Was that
Lordship,
obtained?
Lordship, normally in claim cases with the true copy it is
No, in
filed.
all cases, you see,
Hmm.
when you want to file without certified copy, you should take leave of the court. Yes, let the delay be condoned. Yes, record an order. Learned advocates for the parties are present, are learned advocates. The application can 1
Can 2
of 2025 filed by the appellant for condonation of delay is taken up for consideration. Heard learned advocates for the parties. Peruse the petition filed. Upon perusing the petition, it appears that the appellant has furnished grounds for condonation of delay of 115 days. Thus, the delay is condoned and the appeal is admitted.
Lordship,
Can
can
2025 stands disposed.
Lordship, can 1 is for the stay application. I have already deposited the
Yes.
statutory deposit.
Yes. The application for stay can 1 of 2025 is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay for a stay of the judgment and award dated 11th March 2025 passed by learned additional district judge, first track, first court Krishnanagar, district Nodia in MSC case number 357 of 2019 for a period of 5 weeks. Stop. The appellant shall take steps to deposit the entire awarded sum along with interest from the date of filing till date of the deposit within the period of 5 weeks. Stop. In
Less the statutory deposit.
no, shall take steps to deposit the entire awarded sum along with interest from the date of filing till the date of deposit, excluding the statutory amount of rupees 25,000 within period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the judgment and award passed by the learned trial court shall remain stayed till the disposal of this application. Okay, liberty to mention. Let the copy of the challan file be kept with the record. Hmm? 34টা ডেকে এবার লেস্ট ডেকে দিনি
My lord, I'm for the appellant. It's a railway untoward incident case.
Can one
days can 166 days delay, my lord.
Okay, let me see.
And there is a valid reason for delay, my lord. Thank you.
Yes. Yes, record and order. Learned advocates for the parties are present, heard learned advocates. This application for condonation of delay being Can 1 of 2025 is taken up for consideration. The appellant in the said application has prayed for condonation of delay of 66 days in preferring this appeal. Stop. Upon hearing the learned advocates and upon perusing the petition, this court is of the view that the appellant has furnished sufficient grounds for condoning the delay. Stop. Thus, the delay in filing this appeal is condoned and the appeal is admitted.
My lord, it's a small case. It's a small matter, in this case, instead
So
of
let the paper books be filed.
paper books. My lord,
Let the paper books be filed within a period of 4 weeks.
4 weeks.
Let this matter.
2 weeks, my lord.
Okay, okay. Let the paper books be filed within a period of 2 weeks.
2 weeks, my lord.
And copy be served. Let this matter appear on 5/1/2026.
5/1/2026. Can it be in December, my lord?
December, last 2 weeks, this bench will not sit.
My lord. Much obliged.
Deeply obliged.
My lord, at 2 o'clock, my lord also has.
2 o'clock, you see, there are 2 judgments.
Yes.
Upon delivery of the judgments, original side matters will be taken up.
After the judgment.
Yes, original side matters will be taken up. Thereafter, 3 p.m., there is another
Yes.
fixed matter.
3:30 also.
Yeah, yes. So other matters will be taken up tomorrow.
Fine. Great.
কল্পনাটা
Yes, I'm reading out the operative portion. In the facts and circumstances discussed above, this court does not find any ground to interfere with the judgment and award passed. Thus, this appeal is dismissed. Judgment dated 19/8/2024, passed by the learned additional district judge, Third Court, Paschim Mednipur, in MSC case number 68 of 2022 is affirmed. Respondent number 1 and 2 are permitted to withdraw the awarded sum deposited upon compliance of required formalities.
Your Lordship, kindly run a register general directed to release the or permitted.
No, permitted.
the parental consortium, my lord, is granted.
All, entire appeal is dismissed.
I'm grateful.
Grateful, my lord.
Yes. Hence, this appeal is allowed in part. Judgment and award dated 23rd August 2024, passed by learned additional district judge, First Track Court, Durgapur, in MSCC 51 of 2018, is modified to the extent that the respondent number 1 to 4 claimants are entitled to a compensation of rupees 56,34,580 along with interest at the rate of 6% per annum from the date of filing till date of this order, upon payment of rupees 40,000 to respondent number 1.
Till payment.
Yes.
Till payment.
No, till date of this order.
It will take so much time by the department concerned.
No.
Yes, my lord, I am suffering in this case also.
Upon payment of rupees 40,000 to the respondent number 1, the balance awarded amount shall be distributed equally to all the respondents. Residuary amount lying in deposit will be returned to the appellants upon compliance of all necessary formalities and upon giving the learned advocates for the parties an opportunity of being heard.
Till realization, it will be helpful.
No, it is deposited. It is not in their hands. You see, that claim amount, they awarded some.
Department, today your lordship has been pleased to pass the order.
Yes.
If it is disbursed after 1 year, then
No, what will be disbursed after 1 year?
So many cases is used to do.
No.
So many,
now you are withdrawing from here.
Yes, I shall withdraw from here.
So now question is, as because they have deposited the sum, why with this court will burden them with further interest? They have deposited.
Not they, my lord. If my lord claimants withdraw by the department from the if disbursed from the department concerned 1 year, after 1 year, there are so many. Then my lord claimant will suffer 1 year interest.
No, question is, you see,
if it is still realization, then my lord claimant.
No, realization means what you are to realize, because they have deposited the amount. Now it is gone. Which department?
Then my lord till payment.
No. Now you have deposited the sum before the High Court. Okay. Now after compliance.
What he's saying, perhaps
yes,
he could not make himself clear. He says that today, we are on 26th of November, 2025.
Yes.
He says, if I get this money from High Court, from my lord's department, my lord's officer, disburses, accounts department, disburses this money on 25th of October, 2026.
Yes.
In case if he gets the money on 26th of October 2026, then he should not be deprived of this interest of this 11 months. This is what he's praying before your lordship. That is why he is saying that till the date of realization, so that he gets this interest for this 11 months for which the money is lying before my lord's officers.
Now the question is, you see, I am imposing interest upon them for no fault of theirs.
No, interest.
My lord,
on
this
the
money,
amount,
which I have deposited, my lord, your lordship officers have deposited it, my lord, in the renewable fixed deposit. হয়তো তুমি বলো নালে আমি বলি my lord, this money is earning interest. He says, my lord, that when he will be getting the money from my lord's department officers, my lord, he should get interest till the date when he gets the money. So that till the date of realization.
Date of filing till date of disbursement.
Till the date of disbursement. My lord, this I'm extremely grateful to your lordship, my lord. On behalf of my learned friend.
Okay, upon payment of so and the balance amount, the appellants will be entitled to take back.
Refund to the insurance company along with all accrued interest.
Yes.
Along with all accrued
balance
interest.
awarded amount shall be distributed to respondents. Residuary amount lying in deposit will be returned to the appellants upon compliance of all necessary formalities.
I'm extremely grateful to your lordship. My lord, my lord had taken note of one particular fact, my lord, that the right to recover has not been interfered with. My lord, your lordship had taken note of.
This is the modification, that much. Whatever was there, some 62 lakh.
Yes.
Paid 56 lakh.
My lord, the difficulty is, my lord, when we go for, my lord, this recovery right, the learned court, my lord, the tribunal, it says, my lord has modified this order and recovery right is not referred therein. That is why, my lord, I was just, my lord, praying before your lordship. One liner, my lord, would help my client, my lord, with right to recover. My lord, the right to recover is not interfered with, my lord. Or my lord has not touched other parts of the award. My lord, either way, my lord is, my lord, kind enough to incorporate.
Okay. Other contents of the order.
Extremely grateful to your, extremely grateful to your lordship.
Partly allowed in part.
My lord, in the previous matter, my lord, I just heard, my lord, your lordship, my lord, as far as the parental consortium is concerned, my lord, your lordship is, my lord, is not interfering with the award which has granted.
Entire thing I have dismissed.
But
everything stands.
Everything stands.
I have given the reasons. Okay, you go.
I'm
through that.
extremely. I'm blessed to my lord. Oh, blessed. Grateful.
Yes. Lordship.
Original side district matter under heading for hearing serial number 1 and 2 Bhutoria Phalv Udyog Limited and another.
Just to recapitulate, my lord, for 5 minutes. Yes. There are two applications, my lord. This is my suit, wherein lordship, there's a suit of 1992 in which certain shares are involved. It is my case that the defendant number 1 has misappropriated his authority as my broker and had made certain transfers that are illegal and fraudulent. And the shares belong to three companies mainly. One is of Tata Tea, another is Grasim, and another is another company, my lord. The Tata Tea, lordship, is one of the companies whose shares are involved in this suit. Well, since there is inception, my lord, it was the stand of Tata Tea that they will not, whatever is the decision of this honorable court, they shall abide by it. They will not get into any of the disputes between the plaintiff and the defendant number 1 and 2 and the transferees who may come. So that was their stand. Now, my lord, they had thereafter made certain illegal. There was an order of injunction which they said that I'm happy with that order of injunction, and they violated it, and there were proceedings. Now they have to get this suit dismissed against them. That is why all these applications have come up. Now, my lord, for several in 1990 suit, lordship, several amendments have taken place, and it is the case of the the applicant Tata T, which is now Tata Consumer, that it is their case that because of non-issuance of writ of summons on them, so the suit has become dead, and they cannot anyway this suit cannot be revived, and this suit ought to be dismissed. So the person who earlier said that I have no problem whatever order be passed in this suit is now directly attacking the suit. So GA 26, which they have filed, is for taking the plaint of lordship, that is a demurrer, or in the nature Order 7, Rule 11. GA 25 is for recalling various orders. Lordship, several orders were passed for amendment, and an order of amendment was passed recently, where the amendment was the Tata Tea was replaced by Tata Consumer, etc., etc. So after that amendment, which was the amendment order was passed in their presence, recording their no objection, Lordship, they have come up for recalling of those orders and all the orders which had been subsequently passed. Lordship, after that order amendment was passed, there is an order which records that they accept the copy of the plaint and they record their waiver of all formalities. Thereafter, my lord, there is a for the other defendants, Lordship, we took out an application for formal lodging of writ of summons. That also was allowed. So, my lord, today, my lord, what cause of action they have for lodging of writ of summons, for dismissal, for non-lodging of writ of summons, Lordship is Lordship has to decide that. Now, my lord, I was arguing GA 26, which is the demurrer application, rejection of plaint. Lordship, I have prepared a short notes, my lord, for your lordship's benefit. I have also annexed the judgment.
May I at least, I don't want his notes, but may I know the judgment? If he was ready, I could have also given you and finished it off.
You have to reply?
Yes, I will certainly reply, yes. But may I know the judgments at least? Because I also have my notes ready, but the judgments, I'll give a reply and then finish it off within maximum 10 minutes.
GA 26, my lord, lordship will say I have tried to, in my notes of argument, lordship kindly takes my notes of argument. I have tried to summarize what is their argument, what is our argument. Lordship, first is the scope, which is for rejection of plaint. The arguments, Lordship will kindly see, it has been argued by the defendant number 6 applicant that the plaint is liable to be rejected in view of the fact that despite several amendments made to the plaint of the present suit by the plaintiffs, writ of summons after such amendments have not been served on the defendant number 6, and in view of the same, the suit has become a dead suit. In view of the non-service of writ of summons with respect to all the amendments carried out in the present suit, the plaintiff is liable to be rejected. This is their argument in both the applications. No law in support of such argument has been cited. So, Mala, this is my first offense against their application. Lordship, thereafter, Lordship, I have quoted Order 7, Rule 11. Lordship knows that A and D is Order 7, Rule 11. A and D is what is relevant, always cited, where it does not disclose a cause of action, where the suit appears from the statement in the plaint to be barred by any law. So, my lord, where it does not show any cause of action, that argument has not been made. And where the suit appears from the statement that it is to be barred by law, that law has not been cited. So neither Lordship has any reason to reject the plaint on clause A or clause D. In the present case, Lordship at page 3, Lordship will find, in the present case, it has not been argued that the suit is barred by any law. In such event, no such law has been cited. Further, has not been pleaded there is no cause of action against the defendant number 6. It has only been argued that non-service of writ of summons would entail the plaint to be rejected. Lordship, on the last occasion, I have read the entire application. No such averment of non-disclosure of cause of action has been made. No law or judgment has been cited in support of such proposition that non-service of writ of summons makes the plaint liable to be rejected. Now, thereafter 11D, I have dealt with the same breadth. The suit is barred by law. No law has been cited. Then non-disclosure of cause of action. Lordship, I have referred the paragraphs in the plaint 9, 11A, 13, 14, 15, 16, where Lordship specific cause of action is there against the defendant number 6. Now,
consider also order 9 rule 3.
No,
that is service of summons, you see. No, that is you are confining yourself to order 7 rule 11.
Yes.
But regarding
Lordship,
order 9,
I know.
there is order 9 rule 2.
Sorry, madam. Where neither party appears.
No, order 9.
Dismissal of suit where summons not served. Rule 2. In consequence of plaintiff's failure to pay costs. This is also there in order 7 rule 11, my lord. Where on the day so fixed it is found that summons has not been served upon the defendant in consequence of failure of the plaintiff to pay court fee or postal charges, if any, chargeable for such services, or failure to present copies of the plaint as required under order rule 9 of order 7, the court may make an order that should be dismissed, provided that no such order shall be made if, notwithstanding such failure, the defendant attends in person or by agent when he is allowed to appear by agent on the day fixed to be him to appear and answer. And Lordship, I have shown those.
The amended plaints were not served. This is the contention.
That I have shown, my lord. It has been served. Lordship, may I show?
My lord, I again repeat the submissions. There were 3 submissions, right? In order 7, rule 11, the dismissal, that's the 26. I'm arguing he had no subsisting cause of action because annexure A, the shares remain in the name of Hon'ble Bhutoria. Even if you accept the amendment, the suit is barred because there is no cause of action in favor of Manju Devi Bhutoria because the shares still remain in the name of Hon'ble Bhutoria. Even if you...
No cause of action at this stage.
At this stage, as on date. And if you ask for another amendment today to again rectify annexure A, saying that it is sir, I will cite one judgment, it is not possible to amend now. That is immaterial. That's on order 7, rule 11. Regarding summons, service of summons, etc., 2 principal contentions. As your lordship said, that the amended plaint, when you were carrying out these 11 amendments, they were not served. They were not served. That's neither here nor there. They were not served. And what is more important, no opportunity was given to file written statement. Because in a summons, if you carry out a summons, right at the top, it is written, file written statements within such and such date. Learned judge said, file it by Monday, after ignoring the previous amendments. I am objecting to that, so I have asked for recalling of these orders in AGH 25. But the principal thing, an order 7, rule 11, application, order 7 dismissal, is because has no subsisting cause of action. That is all.
Yes.
Lordship, may I answer to them? Lordship, I have dealt with them.
Anyway, you have dealt with order 7 rule 11. Neither of the grounds under Order 7, Rule 11 is fulfilled here.
Fulfilled. If they are on Order 7, Rule 11.
Yes.
So some law has to be shown, my lord. Just because it has been said, it won't be taken as on face value. Order 9, Rule 3, Lordship, I have shown that it is not for non-insufficiency of court fees. In any event, the proviso says that if they appear, the Order 9, Rule 3 cannot be invoked. And this is, my lord, not a case of the non-lodging of writ of summons from the inception. This is for amendments. Lordship, after lodging of writ of summons, they have appeared. Lordship, it is in their application, they have annexed those documents that they have initially they have received the summons. So, my lord, page 4, clause D, statements made in the plain to be true and correct. My lord, this is with in continuation of non-disclosure of cause of action that that has been made. My lord, non-disclosure of cause of action. I have stated in para 9, 11A, 13, 14, 15, 16. Lordship, I have made allegations. There is a cause of action against the defendant number 6. And at this stage, whether those are true and correct, that has to be taken to be true. Now, my lord, there comes the important factual issue. The defendant number 6 has always received the amended plaints. Lordship, in this respect, my lord, Lordship will kindly see the affidavit in opposition to GA 26 of 2024. Lordship, I have specifically referred to page 35, 36, 37, and 40. Lordship, we kindly see the from page 35, 36, 37, and 40.
This is Tata Tea Limited. 6.
Lordship, that is 36, 35.
7.
35, Lordship will see.
35. Yes.
This is given to the learned solicitors representing Tata Tea Limited. They are still representing. Page 35, and Lordship will see the contents. In terms of the order dated 7th May 1997. Kindly see page 35.
Yes, yes.
In terms of the order dated 7th May 1997, passed by His Lordship the Honorable Justice Shujit Kumar Sinha, we send herewith a copy of the amended plaint upon you. So, my lord, the amended plaint is served on them. That is in terms of the order, and I'm sure, my lord, say if the order dated 7th May 1997, if found, my lord, from the records, it will say that service of writ of summons, formal writ of summons, is waived. That is extremely common.
Where is this? That I have service of summons when a opportunity is given to file a written statement in a summons that I have waived it? Where is it?
Now, here what he is relying is in terms of the order.
Yes, he has served. Served a copy of the.
So the first contention, it has never been served. It is a total.
It is served by the department.
It's completely misconceived.
The summons contains a date. Within such and such date, you will have to file written statement.
For amended plaint is concerned, it is served.
It has been served.
It is amended plaint. He served a copy of the amended only once, 97.
I shall show others also.
Where is the summons?
Also
Opportunity to file written statement.
35, 36, 36. So I not only serve on the solicitor, 36 is I serve on the defendant number 6 directly. Lordship will see Bishop Lefroy Road address has been served.
Yes.
Thereafter, kindly sees Lordship page 37. Another covering letter, my lord. And number 6, Lordship will find Tata Tea Limited.
Yes.
Through their learned advocates, such and such. And there is an endorsement right beside it. Received, and there's a stamp of the solicitor, my lord. And Lordship, see the contents of this letter also.
Yes.
Page 39. In terms of order dated 24th April 2014, passed by His Lordship, the Honorable Justice I.P. Mukherjee. I send here with a copy of the amended plaint upon you. So in terms of the orders, Lordship, they are receiving the plaint. So amended plaint again, they received. Then, my lord, page 40. Again, my lord, I have been able to find out only these documents, but I'm sure for all the amendments there are similar letters which they have received. Lordship, page 40, Lordship will see again, Tata Tea Limited, through their advocates, and there is an endorsement. Yes. And page 41, the contents of the letter. I am acting on behalf of the plaintiffs in the above referred suit. Please find enclosed a copy of the amended plaint filed in the said suit. Kindly accept the copy of the amended plaint and acknowledge the receipt of the same. So, my lord, I have been able to give 4 documents at least in the affidavit of opposition. I have annexed those. And there's no denial in the evident reply that these are forged, I've never received. No denial. They say that it has to be served through the department. That is their only argument. My lord, now kindly see, my lord, at no point of time the defendant number 6 have ever raised. I'm going back to my notes, my lord. The defendant number 6 ever raised any objection with respect to such service. It is a common practice of the original side of the Honorable Court that service of free writ of summons is waived. Further, in terms of original side rules, being Chapter 8, Rule 25, an advocate is also empowered to receive service of all notices summons. Thus, the defendant number 6 applicant must have waived their objection with respect to such service of amended plaint. The defendant number 6 also appeared during various hearing of the present suit. Because this is an old suit, the plaintiff is able to show at least one such order appearing at page 42. Lordship, just the page after that, page 42, I have shown that the defendant number 6 was represented in the opposition. Yes. Lordship, the defendant number 6 is represented, my lord. So, my lord, at page 42, wherefrom it shall be the defendant number 6 was represented. So, my lord, it is not a case that the defendant number 6 had no idea about what is happening in this suit. So they appeared in the suit, they were receiving summons, they were contesting proceedings. Only after, Lordship, the violation of injunction and we filed a contempt, my lord, all these have come up. Now, my lord, thereafter, my lord, waiver and estoppel. As stated, Lordship, I'm coming back to my notes, my lord. As stated, the defendant number 6 had always received the amended plaint and participated in the hearing of the present suit, which shall be evident from pages 35, 36, 37, 40, and 42 also, my lord. No objection has ever been raised by the defendant number 6 or any other defendant. Therefore, by its conduct, the defendant number 6 has waived its objection, if any. In any event, after having participated in the hearing of various applications and other proceedings in the present suit, the defendant number 6 is stopped from raising any further issue with respect to, Lordship, non-service of writ of summons. Now, my lord, there were then 5, my lord, whatever has been said thereafter, just now, those are, Lordship, I have placed the entire application, Lordship, but during the course of hearing, there are certain arguments which had been made beyond pleadings. During the course of hearing, the following arguments were made by the applicant beyond the pleadings in the said application. The first, which was just stated again, after the death of Manmal Bhutoria, original defendant number 3, no application for transmission has been filed by the plaintiffs before the defendant number 6. And the schedule of shares being annexed A to the plaint had not been amended, and hence no cause of action of the substituted defendant number 3, Manju Devi Bhutoria, survives against the defendant number 6. This is their first argument. And if the plaint be not rejected, at least the name of the defendant number 6 be expunged. This was a half-hearted argument which was made just before conclusion. Both the arguments have been made without any pleadings in the present application. The above two arguments have been made during the hearing of the present application. There are no pleadings to this effect in the applications. It is settled law. Parties are not allowed to argue what has not been pleaded in the application. Further, there cannot be a mini trial at the present stage in order to decide whether by not amending the schedule of shares or by not filing any transmission application, there is no cause of action of the defendant number 6. So, my lord, in this respect, my lord, Rashid, what will happen during transmission of shares? Rashid, I have to give the physical shares to their share transfer agent along with the copy of the order, and I say that you transfer these shares. These physical shares have to be now dematerialized, and the dematerialized share has to be sent to a demat account. Rashid, that demat account, we shall be providing that this demat account being the heirs of the shareholder, it shall be transmitted to that account. Rashid, transmission of shares is, Rashid, with Succession Act. My lord, there is no limitation to succession, my lord. If I, if this property was a land, every time a person dies, I have to say that this has to be, the transmission is by operation of law. That is Succession Act, my lord. This is transmission is not a choice which I have to exercise.
By act of the parties.
It is not by act of the parties. It
But
is by operation of law. It is Succession Act. So, my lord, the transmission, lordship, this argument is not helping them at all. As stated, the statements made in the plaint ought to have been taken to be true and correct at the present stage. Therefore, defendant number 6 is a necessary party and no question of expunging its name from the cause title of the present suit. Lordship, I have referred to those paragraphs where I have made those allegations. Without prejudice, the argument of the application, the claim, the Lordship, the Roman 6, claim of the applicant is at best a curable defect. Without prejudice to the fact that the argument of the applicant is misconceived, it is stated that the same may at best said to be a curable defect, and defect shall be cured upon service of fresh writ of summons. By order dated 9th February 2025, the Honorable Court has granted leave to lodge writ of summons against the defendant number 6, and the fresh writ of summons has already been lodged. Thus, the application of the applicant has become infructuous. The application has been filed in order to delay the hearing of the present suit.
This 9th February 2025.
Yes.
This order was passed on this GA25 application.
GA24.
No, this is okay. GA24.
Yes, it is part of GA25.
Part of
the next application GA25.
We have asked for recalling of all these orders from
so GA24 application
disposed of.
By passing this order.
By passing.
By
I shall place that while placing GA25.
Yes.
So, my lord, this
is GA25.
No, this is GA26. This is demurrer.
Okay.
This is order 7, Rule 11.
That is rejection of the plaintiff.
Yes. And thereafter, Lordship, I have cited a very recent Supreme Court authority. Lordship, on a Lordship, is very settled law. Lordship need not. Lordship knows it already. Paragraph 8, that the statement made in the plaint is taken to be true and correct. Lordship, may I place paragraph 8 of the judgment? Lordship will find it is at page.
But I am also relying on this. Statements in the plaint are to be taken true and correct. I am fully relying. In fact, I wanted to cite one judgment, reply on this proposition, but I'll rely on his judgment.
It's at page 5.
This is exactly what I'm saying.
There's the internal page 5, my lord. The proposition of law is that paragraph 8. Is that rejection of a plaint under order 7 rule 11 is permissible only when the plaint on its face and without considering the defense fails to disclose a cause of action, is barred by any law, is undervalued, or is insufficiently stamped. At this preliminary stage, the court is required to confine its examination strictly to the averments made in the plaint and not venture into the merits of the suit. Cannot be summarily, merits or veracity of the claims. If any triable issues arise from the pleadings, the suit can be summarily rejected. Keeping in mind this settled principle of law, we proceed to examine the. This is a very settled, my lord, proposition of law, which is that the statements made in the plaint is to be taken true and correct. That is paragraph 8 is only the paragraph which I am going to rely on. So, my lord, in my humble submission, GA 26, Lordship has really not stood the test of Order 7, Rule 11, or any judgment in this country which has been passed that non-lodging will actually make the suit
Two
plaint
issues
be
that is
rejected.
regarding that summons aspect, that is the non-service of the amended plaint, and the third is this, the
No cause of action.
no cause of action at
Survived.
survived. So whether the court will invoke the inherent power or not to prevent the abuse of the process.
Yes. So there I have said, my lord, I need not.
Inherent power. On the reading of the plaint, if you find there is no cause of action as on date.
If the plaint does not disclose cause of action.
Cause of action as on date, because by not amending Annexure A. What is the effect?
Annexure is a schedule of shares.
That is, well,
Schedule of
and the
shares.
release.
Amending schedule of shares,
Someone.
So, that is my argument with respect to
Originally, by
J26.
virtue of Annexure A, he was entitled.
No.
Originally,
husband was entitled. Manmal was entitled. Shares still remain from 91 in the name of Manwal. Substitution says, I have become the owner of the shares. Someone else, on the basis of some will. Not some person, one person.
One judgment on this proposition. One judgment.
I will give
be.
you.
I would be very happy.
I will give you.
So why in reply?
No, why in
Why in
reply?
reply?
Because you said during argument.
let him clarify in reply.
Because he said, and you can deal with it.
Originally, the cause of action was
again Manmal.
Now,
Substitution took place in 99. Substitution took place in 99. Manju claiming, I am by virtue of some will, probated will.
That document does not corroborate the case of the plaintiff.
Because that's not the argument. That is their averment. I must.
No cause of action is one thing.
Yes.
And the document does not corroborate.
The plaint. Corroborate the plaint.
Whether it should be rejected at this Order 7, Rule 11.
Correct.
Or at a subsequent.
Correct. That should be rejected now, whether there is a subsisting cause of action or not. That you have to decide. So that they said, this is a mere technique.
I've got cause of action against 11 defendants are there.
That is a separate.
No, Mr. Basu said that if it cannot be rejected at all, let at least defendant number 6 go.
That's
let
the law.
Man go.
If you want a judgment.
That cannot be.
No.
Because the cause of action I have pleaded.
He wants you to release his client.
Yes.
Because they have acted in contempt.
So whether contempt, there is a contempt, you have filed the contempt later on.
You proceed with the contempt. That nobody is preventing you.
But the suit, this will, I'm taking this point.
No, suit.
You have.
Anyway, you just.
Lordship.
You have woken up a wounded tiger. Now face it. Whether you are contempt.
Tiger was not wounded. Tiger got himself wounded with the act of contempt.
You see, on that point, you see, regarding amendments and service of amended plaint or something, you see, the court may try to consider your case. If you can show sufficient grounds,
correct.
The court may try to
I am obliged to you that court never dismisses on the ground
and show sympathy to you.
Sympathy, my lord, provide
regard to that cause of action.
Yes, and sympathy, my lord, you must give me not 1 day's time to file written statement.
1 day?
Yes, that was given. File it by Monday of 11 years amendment.
That was their counsel who was represented. I did not say that.
Because you did not serve the summons.
That was a court's order.
Court order. I'm asking for recalling of that order.
So let them file written statement. I'm not standing in the way.
No. So
even if your recalling order succeeds, then regarding, and if he suppose.
If recalling order succeeds, then also it's barred by by no cause of action. I'm saying.
That pleading.
My lord, you only look at the plaint.
The GA 26, Lordship, I have completed, my lord.
J26 that according to you, the
G25
applicant,
বলবো।
according to you, the applicant, defendant number 6, has hopelessly failed to substantiate his case under Order 7, Rule 11.
Under Order 7, Rule 11, no cause of action, if there is no cause of
That means
action,
hopelessly
or
failed.
barred by law. But no law has been showed, and cause of action, Lordship, I have given the paragraphs where I have made averments against the defendant number 6.
Amended plan, entire compliance is made by you.
And if there is a for non-amendment of a schedule of shares, Lordship, that is a schedule which I have prepared. Lordship, kindly seize then the plaint, my lord.
My lord, I believe you have a matter fixed at 3,
Three.
and he said he'll continue. My lord,
So you will take a day for reply?
not
Another
day, no, half maximum. You should
Yes,
not give
another
me.
day has to be
Yes,
fixed,
yes.
reply.
Only one thing I must tell him so that he can deal with this. My lord, during his course of argument, and even today he said this is amendment of the schedule. Amendment of schedule, my lord, is a technical thing. It's a curable thing. You can again amend the. He did make this submission.
No, he has confined today only with 226.
No, he did. 26. He said it's curable. It's a technical, just by saying in the schedule, it doesn't matter, etc., etc. My lord, I just want to cite one judgment. Let him deal with this. That, my lord, if it is if the suit is barred under Order 7, Rule 11, no amendment at this stage cannot cure. My lord, at this stage, you can take the judgment, please. 2021 7 SCC 456. Parata bole dao.
Anyway, give your compilation.
Para
What-
10.5.
No, with your written notes, give your compilation.
I will, my lord. Now I know what cases he will
Yes,
submit.
yes.
I will prepare it and just hand it over. My lord, may I take your?
Lordship, kindly takes GA26, my lord, the application. Page 89 is the schedule of shares.
Page 89, that is volume 2.
Lordship, no, my lord. Volume 1, page 89.
GA80. Yes, page 89. Yes.
Lordship will see in the middle, Tata Tea Limited, and within bracket, as it stood in 1992, Manmal Bhutoria, Lordship has seen.
Yes.
138, there is a distinctive numbers or something, which is the share numbers, my lord. 1,000 shares. This is, and there is also Bhutoria Engineering Works, which has now become Bhutoria Valve Udyog. And there is also distinctive numbers and 2,400. My lord, it is the contention of my senior friend, my lord, that this Manmal Bhutoria ought to have been replaced by Manju Bhutoria. Only then the cause of action survives. Now, my lord, kindly seize paragraph 4 of the plaint. Page 51, I'm sorry.
Yes.
At all material times, the plaintiff number 1 and the original plaintiff number 2, Manmal, have been and still are registered holders, owners of inter alia such and such shares of 4, 5, and 6. The material particulars of the said shares, so you will see, the particulars of the said shares, their respective distinctive numbers, etc., are set out in schedule hereto and annexed as marked A. So, my lord, A is really particulars of the shares which are the subject matter of the present suit. So, is it the case, I want to understand, my lord, is it the case, I'm thinking aloud, of the applicant that it was not in the name of Manmal Bhutoria? It is only the particulars.
Original plaintiff is concerned, he had a right regarding, and the document corroborates his case. Thereafter, that right is inherited by the substituted plaintiff. So this is your case, that right is inherited by the substituted plaintiff.
By operation of law.
By operation of law. But that document does not corroborate. That is the thing.
Yes.
This document does not corroborate the sum of the case of the plaintiff.
That is why, my lord, I have failed to understand the argument. How it does not corroborate, at least say that I can meet that point, my lord. How it does not corroborate? Because it only says Annexure A is particulars of the shares which are subject matter of the present suit. Annexure A says Tata Tea Limited. Manmal Bhutoria is the name of the shareholder.
Application was allowed that the cause of action continues. Definitely
continues.
If that you see that order of substitution, that cause of action continues, whether that finding was there by the court, then that is the ground that yes, cause of action continues. If cause of action continues, then you have a support from the order of the court. So cause of action continues. So it is only when the cause of action continues.
Only then substitution happens.
No, the suit is not abated, and the suit has to be continued by the years.
Then, my lord,
so where is that order that the cause of action continues and the
had it been at least this thing pleaded, I would have tried to produce the order. There has to be some basis. Whether now it is then during the argument.
No. To build up your case, you have to come out with these documents, because yes,
it is their case,
yes,
my lord,
the
not
court,
my case.
Court, upon considering the facts, has come to these findings. Yes, cause of action.
I shall
because
show
of this record. The court has come to a findings.
Lordship, kindly
that
sees.
Substitution, if that substitution order was not challenged, then it has reached its finality.
Lordship, let this, my lord. This has not been challenged. Till date, not been challenged. Now, my lord, kindly sees Order 22, Rule 3 of CPC.
Yes.
Order 22, Rule 3 of CPC.
Yes, Order 22.
Who can be substituted?
Yes.
Where one of two or more plaintiffs, Lordship, proceeded in case of death of one of the several plaintiffs or of sole plaintiff. Where one of two or more plaintiff dies and the right to sue does not survive to the surviving plaintiff or plaintiffs alone, or a sole plaintiff or a sole surviving plaintiff dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representative of the deceased plaintiff to be made party and shall proceed with the suit. Where within the time limited by law, no application is made under Sub-Rule 1, the suit shall abate so far as the deceased plaintiff is concerned, and on application of the defendant, the court may award him the costs which he may have incurred in defending the suit, so to be recovered from the estate of the deceased plaintiff. So, my lord, my application under Order 22, Rule 3 could have been allowed, could not have been allowed unless I have substantiated and established that the right to sue has survived in the legal representative of the deceased plaintiff. Lordship, in the absence, Lordship, I do not have the order right now, but it is Lordship has to assume that as per even Evidence Act, whatever has been done in accordance with law.
Anyway, let us consider the court's order. Anyway, it is an admitted position that
substitution has happened.
Substitution was allowed.
Was allowed. And substitution could not have been allowed unless the right to sue survives.
So that is the question, whether the cause of action still exists or not. That is the basis of substitution application. Whether, anyway, you have not relied upon this document, because now if you want to rely, you have to file a supplementary affidavit.
Because they have not relied upon. Their application, there's no whisper about these things.
Oh, this point is left open to you, that if you want to take this point, that an order of substitution is made when there is a cause of action, not otherwise. If the court is satisfied that there is no cause of action, he could have.
Lordship, since it was their oral argument, kindly considers my oral reply, my lord.
Okay.
That
Anyway, conclude on the next day.
Lordship
Because
fixes
3 p.m.
any
there
date,
is
my lord.
another.
At J25, I shall take half an hour, my lord.
Yes, record an order. Learned advocates of the parties are present. Heard learned advocates, as the hearing could not be concluded, let this matter appear for further hearing on.
My lord, may I make one subject to my lord's convenience? My lord, may it be any day starting from the week starting from the 8th, my lord?
Starting from 8th. You have any difficulty on 8th?
No, any day, lordship.
Yes. On 8/12/2025. Hey, সিদ্ধার্থ বাবুকে ডাকুন তো একটু। আচ্ছা, 8/12 কি কোনো ফিক্সড আছে?
ওখানে কি কানানি সব হয়ে গেল?
কিছু নেই। Okay, 8/12/2025 at 2 p.m.
Grateful, my lord.
I'm grateful, my lord.
Item number লিখবেন 78
Yes, call the appellate set fixed matters.
In this matter, I'm appearing for the appellant, my lord. I'm being led by Mr. Probal Mukherjee.
My lord, I'm appearing for the respondent plaintiff in this matter, who is also the landlord.
You are for the appellant.
I'm
My lord, I'm respondent, my lord.
It's my appeal.
So start.
Paper book and a supplementary paper book.
দেখুন তো এমনি একটা পেপার বুক আছে,
আগে ফাইল আছে
একটা পেপার বুক তো অ্যাপিলেন্ট যেটা ফাইল করেছে, আর একটা সাপ্লিমেন্টারি দিয়েছে, এটা ফাইল করেছো কোনো?
না, এটা বলেছিল
আচ্ছা,
যখন ডাক হবে এটা আমরা বলেছিলাম। ওটা তো আমাদের কপি দেবো।
কোথায় আছে? ও
ওই তো
তিনটে পেপার বুক দিয়েছে।
মেইন পেপার তারপর ফাইল
করে দাও। এটা কি?
সাপ্লিমেন্টারি করে প্লেন প্রেজেন্ট স্টেটমেন্ট ইস্যুস, ডেফিনেটলি চিফ ডিপোজিশনস গুলো আলাদা করে একটা পুরো,
হ্যাঁ হ্যাঁ,
এটা আলাদা করে আছে, এটা
আচ্ছা ঠিক ঠিক আছে।
এটাই
Yes, you are for the opposite party.
No, Lord, I am for the appellant tenant.
You are the appellant.
I am the appellant.
Yes. Yes, what are the grounds on which
Yes,
this appeal
Lord,
is to be heard out?
that your lordship will find, Lord, there are two substantial questions of law which your lordship will find, Lord, at the 129, page number 129.
29. Yes. Yes.
So, Lord, so far as the first point of law is concerned, I need to take your, Lord, this is a judgment of reversal. The trial court, Lord, dismissed their suit. The suit was based upon, Lord, two grounds. One was reasonable requirement. The other was, Lord, default. The trial court dismissed the suit, and Lord, it was reversed by the appeal court only on the ground of reasonable requirement of, Lord, the employees of the plaintiff company.
Yes, trial court, and that was reversed by the appeal court.
Yes. So, Lord, why it was reversed? Lord, I'll first take your lordship to, Lord, the trial court's judgment. Thereafter, Lord, the appeal court judgment, and then, Lord, I will take your lordship that what are my points before your lordship. That why the appeal court was wrong.
Yes.
And Lord, so far as the ground number 2 is concerned, Lord, your lordship knows, Lord, that this is a purely a question of law as to, Lord, whether the court should consider the question of partial eviction prior to passing an order of not eviction.
That is
Therefore,
not
that is a
consideration of this aspect, non-consideration and addressing himself on this issue.
Absolutely. By the first appeal court on reversal.
Yes. Yes.
But the trial court, your lordship will find at page 2 of the paper book. But today, এখানে কি paper book গুলো দিয়ে দিয়েছো? Oh, Lord, we have made compilation of other papers for the convenience of the court. Lord, may we just file those?
Compilation of
Yes, Lord, yes.
documents.
Lower court documents. And
This is the paper book. That is what compilation.
Lordship. In a second appeal, your lordship will hardly get anything in the paper book. Only the judgment and decree. But your lordship,
the scope is also limited.
The scope is limited, but
All
not
details examination.
Because the first question of law, your lordship has to go through the evidence. Because that's not the first question of law, but whether the reasonable requirement has been proved before the first
There
appeal.
is no concurrent findings. That is the thing.
There's no concurrent finding. There's a reversal.
Yes. So let me consider the judgment of the trial court.
Lordship. Your lordship may start from page 3.
Yes.
This is a suit for eviction filed by SN Alloys Private Limited, a company incorporated under the Companies Act, against Texan Sayo, hereinafter referred to as defendant, valued at rupees such and such. So, not the plaintiff is a company.
Yes.
The thumbnail sketch of the plaintiff's case is that the plaintiff is the absolute owner of flat number 1A on the first floor of Nilkant building, which has been more fully described in the schedule annexed to the plaint hereinafter referred to as the suit premises for short. That the defendant is a monthly tenant in respect of the suit flat at a monthly rental of 2475 payable according to English calendar month. That the plaintiff purchased the suit property from one Sudha Bait by virtue of a registered deed of conveyance dated 18th November 2011. That after purchase, I was an old tenant under Sudha Bait, and he is not a transferee landlord. Now the present plaintiff. That after purchase, plaintiff's vendor, Srimati Sudha Bait, sent
Which paragraph? Para 5.
Para 2 I am reading at page 3.
Para 2 at page 3.
Of the paper book. Of the paper book. No, yes, there. No, compilation. Paper book.
Yes. Yes, page 2.
Lordship. The page, kindly come to page 3, paragraph 2.
Page 3, paragraph 2. Yeah.
Lordship. It starts with the thumbnail sketch of the plaintiff's case.
Yes.
I was up to, Lord, that monthly rental about 5-6 lines, monthly rental of rupees 2475 payable according to English calendar month, that the plaintiff purchased the suit property from one Shudha Baid by virtue of a registered deed of conveyance dated 18 November 2011. That after purchase, the plaintiff's vendor, Srimati Shudha Baid, sent a letter of atonement on 17 January 2012 to the defendant, directing the defendant to atone the name of the plaintiff and pay rent month by month to the plaintiff directly. That in spite of receipt of the said letter of atonement, defendant did not pay any rent to the plaintiff, that the defendant was originally a tenant under Shudha Baid, and after purchase, defendant became a tenant under the plaintiff, and in spite of having knowledge that the plaintiff was a landlord, the defendant deposited rent at the rate of 2475 per month in the name of Shudha Baid at the office of the learned rent controller, Kolkata. It's further case of the plaintiff that the defendant was inducted in respect of the suit premises pursuant to an agreement entered into between the previous owner Shudha Baid and the defendant on 15/5/1976. That from the terms and condition of the said agreement, it will be evident that the suit premises was let out for residential purpose. It is further case of the plaintiff that the predecessor in title of the plaintiff had filed an eviction suit against the defendant, being ejectment suit number of 1983 in City Civil Code, Calcutta, and subsequently due to amendment of the City Civil Code Act, all the suits which are valued below 30,000 were transferred to Court of Small Causes, Calcutta, and ejectment suit number of 524 of 1983 was transferred to the Court of Small Causes, Calcutta, and was renumbered as ejectment 504 of 2001. It is further case of the plaintiff that Shudha Baid filed an eviction suit before the Honorable High Court at Calcutta, being CS number 1 of 2004. And in course of proceeding, it was adjudicated that the suit was filed in misconception of law and that the suit was governed by the West Bengal Premises Tenancy Act. But the suit was filed as per provision of section 106 of the Transfer of Property Act. Subsequently, the said suit was being CS 01/2004 was withdrawn by Shudha Baid on 10/4/2013 with permission of Honorable High Court with liberty to file afresh. That subsequently fresh notice was issued dated 22/4/2013 and the said notice was duly received by the tenant on 25/4/2013. That in spite of receipt of the notice of eviction, the defendant did not quit and vacate the suit premises, for which the plaintiff had been compelled to file the instant suit on the ground that the defendant is a defaulter in payment of rent in respect of the suit premises from November 2011, and that the plaintiff reasonably requires the suit premises for his own use and occupation, as the plaintiff is a non-banking financial corporation and has its registered office at 8 Kamak Street, Kolkata 17. It is further case of the plaintiff that the plaintiff has 9 staff employees in their organization, including manager and assistant manager, and that in terms of the service contract, plaintiff has to provide residential accommodation to the senior staff, namely manager and assistant manager. That since the plaintiff has given accommodation of their own for providing accommodation to senior staff, the senior staff are provided rented accommodation on 11-month leave and license fees, for which the plaintiff has to incur huge cost towards payment of license fee every month. There's a further case of the plaintiff that the plaintiff wants to diversify its real estate and iron and steel business, and for which the directors and promoters have already invested 2.5 crore by way of share capital during the last 2 years, and for which more staff will be it must be required, and as per the service contract, the plaintiff will have to provide residential accommodation to those staff also. The plaintiff has stated that the plaintiff requires the suit premises to provide residential accommodation to the manager and assistant manager. It is further allegation of the plaintiff that the defendant is using the suit property for the purpose other than for which it was let out, and that the suit property was let out for residential purpose, but the defendant is conducting speech therapy center, which is purely commercial organization from the suit premises. Plaintiff has therefore...
Oh, the suit property is used for what purpose? Residential or business?
Residential, and Lord, he used to practice speech therapy.
That is the profession.
That is a profession.
That means how many rooms are there in the suit property?
That is a flat. That is an apartment. Comprises
flat?
of...
How?
Yes.
Area of the flat?
Yes, it's about 1600 square feet.
1600 square
1600
feet.
something.
100 square feet plus 300 square feet of roof space, open terrace.
Open terrace.
Okay,
Total is 1900 square feet.
1600. Okay, regarding, you see, one room is for residential, the other is for this.
No, there is no.
There is no residential.
No, it was an entire flat. Part of it was used for residential, and
Yes,
part of
that
it
is what
was
I'm asking.
like not a lawyer's chamber. A lawyer might be not
Partly for
residing.
residential, partly for professional.
Lordship.
And the number of occupants in that in the suit property?
But so far as my client is concerned, Lord,
Yes.
now he is dead, and Lord, the wife stays there.
So
The spouse.
prior to that, only husband and wife.
Husband and wife. Oh, chale mein chalo, bijo. Na, chalo.
Yes.
But I'll take your lordship Lord, to the commissioner's report. There is a commissioner's report there. The plaintiff has therefore alleged that the defendant has acted contrary to the agreement of tenancy and is entitled to be evicted for being guilty of violation of clauses MOP of section 108 of the Transfer of Property Act. It is a further averment of the plaintiff that the defendant has made special conversion without obtaining any written permission from the plaintiff. The plaintiff has further alleged that the defendant is guilty of waste and negligence and causing material deterioration of the condition of the suit premises. The plaintiff has inter alia prayed for a decree for recovery of khas possession of the suit premises, stating the cause of action to have arisen on the first day of June 2013 within the jurisdiction of this court. Defendant contested the suit by filing written statement, and in the written statement, defendant denied all the material allegation made in the plaint and has stated that this court does not have any jurisdiction to entertain this suit, and that the suit is not maintainable, and that the suit is bad for non-joinder and misjoinder of necessary parties, and that the suit is barred by law of limitation. It is also barred by principles of estoppel, acquiescence, and there is no cause of action to file the instant suit. Is a positive averment of the defendant that the defendant was inducted as a tenant by the landlord Ashok Baid, Hira Kumari Baid, and Shudha Baid in respect to the suit flat at a monthly rental of rupees 3,000, including maintenance charges of rupees 900.
So the plaintiff is a limited company.
Plaintiff is a limited company. That one of the landlords, namely Hira Kumari Baid, died, and after her death, the defendant became the tenant under Ashok Baid and Shudha Baid. It is further admission of the defendant that the erstwhile landlord filed a case being number 21 of 1978 against the defendant for recovery of arrears of rent in Small Causes Court, Calcutta, and the said proceeding was compromised, and as per compromise, rent was reduced to rupees 2475, including maintenance charges, lighting of common passage, staircase, and all services. That the defendant paid the said amount to the landlord up to May 1982, and thereafter the defendant came to know that the defendant did not pay the corporation tax, service tax to the owners association. The defendant has alleged that the association has threatened the defendant for disconnection of essential services. That the defendant filed a title suit being number such and such against the erstwhile landlord, that the defendant had preferred FMA number such and such against the order dated 14/10/1982 and order dated 23/8/83, and the Honorable High Court via order dated 2/2/1989 directed the defendant to pay to the owners association the actual liability of the owner and the balance amount of rent in the City Civil Court, Calcutta. That in terms of the said order, defendant started to pay corporation tax and maintenance charges to the owners association and rupees 819 in the suit to the credit of the erstwhile landlord, and subsequently the same was decreed ex parte by order dated 17/4/2007 filed by the learned 6th bench, City Civil Court, Calcutta, and vide such order. It was declared that the defendant were liable to pay the maintenance charges of the suit properties and to provide for facilities to the plaintiff through pro forma defendant. It is further case of the defendant that subsequently Shudha Baid, claiming herself to be the sole owner of the premises on the basis of deed of conveyance dated 22/2/2001, claimed against the defendant, praying for a decree for recovery of khas possession and other relief, that during pendency of the said suit, Shudha Baid informed the defendant that she sold the suit flat to the present plaintiff, that the defendant via a letter dated 1/10/2012 informed the present plaintiff that he was paying the maintenance charges of the building to the association as per the order of the Honorable High Court, And if the plaintiff was agreeable to take responsibility of paying maintenance charges to the association, defendant was ready to pay the total rent to the present plaintiff. His further averment of the defendant that the plaintiff in its letter dated 11/10/2012 invited the defendant to take inspection of the sale deed, that subsequently Sudhabai withdrew the suit being CS number 1 of 2004 from the Honorable High Court. Defendant admitted that the defendant received a notice of ejectment dated 22/4/2013, and after receipt of the said notice, defendant tendered rent to the plaintiff by money order dated 5/6/2013. And after refusal by the plaintiff to receive the money order, defendant started to deposit the rent with the Office of the Learned Rent Controller, Calcutta, on and from May 2013 till August 2013. And that after appearing in the suit, the defendant filed application under Section 7(1) and 7(2) of the West Bengal Premises Tenancy Act and has been depositing rent regularly before this court. Defendant has denied that the plaintiff is the owner of the suit premises, and that the defendant has further denied that the premises was let out for residential purpose. Defendant has specifically stated that in the agreement of tenancy dated 15/5/1976, which was specifically mentioned that the said flat would be used for residential cum clinic purpose. Defendant has specifically stated that the defendant deposited the rent in the name of Sudhabai till April 2013. And after withdrawal of the suit, defendant started depositing rent in the name of the plaintiff at the Office of the Learned Rent Controller, Kolkata, from May 2013. Defendant has denied that the plaintiff reasonably requires the suit premises for his own use and occupation, and has denied that the plaintiff does not have any reasonable and suitable accommodation, and has further denied that there are 9 staff or employees under the plaintiff organization. Defendant has further denied that there are leave and license agreement between the plaintiff and other licensors, and that the leave and license agreement are manufactured for the purpose of the suit. The defendant has denied that the residential accommodation is required to accommodate the manager and the assistant manager of the plaintiff company, and has further stated that the defendant Messrs. SN Alloys Private Limited are involved in real estate business, and Arun Sancheti is one of the plaintiff, and he is also the director of many other private limited companies, and that Arun Sancheti has a big office being room number 503A on the 5th floor of Shantiniketan building at 8 Kamak Street, Kolkata 17, and that Arun Sancheti is the owner of this should be flat 10B, 10C, 10D at Nilkant building, and flat number 10B and 10C are in the name of Arun Sancheti, and flat number 10D is in the name of Messrs. Sancheti Products. Defendant has further stated that the defendant has not done any act in violation of clauses MOP of Section 108 of the Transfer of Property Act, and the defendant is not guilty of any waste.
On what grounds the eviction decree was passed? Only on reasonable requirement.
Reasonable requirement.
The other grounds were not accepted.
No, the default was not accepted because I complied with 717.
And the other is with regard to this MOP, that is also not accepted.
Not accepted. No, accepted. No, only reasonable requirement. Then, Lord, may I just skip over, Lord, the issues which have been, Lord, dealt with. Then, Lord, issue number 4, Lord, that is the default.
Anyway,
issue number 5.
That has gone against the plaintiff.
That gone against the plaintiff.
Yes. Only issue number 5 is decided against your client.
Lordship. Not by the trial court, but by the appeal court.
Yes,
this is
by
the trial court. The trial court dismissed the whole suit, disbelieved not their case.
So the appeal court has held against your client with regard to issue number 5.
Lordship. Lordship. And yet again at page 11, your Lordship sees, Lord, the issues concerning MOP of 108, those are also, Lord, were issues in the suit. Now, Lord, the trial court, Lord, I'm just not taking your Lordship, Lord, to those entire paragraph dealing with, Lord, the evidences. The important will be, Lord, the commissioner's report, which I'll take your Lordship later on.
So the first ground is, you see, with regard to first ground.
Lordship.
Yes, misappreciating the evidence.
Lordship. So that will bring within the ambit, Lord, the entire, Lord, the
That is, evidence is the matter of fact.
Here.
And whether you see on the basis of these evidence, this decree could have been passed or not.
Reasonableness of, my lord, the requirement of the plaintiff in the facts of this particular case. They are having alternate accommodation, and the accommodation required for, my lord, the employees, whether it is a
Whether
bona fide
the-
requirement.
Whether their claim is at all in the reasonable in accordance with the West Bengal Premises Tenancy Act or as per the in the view of the court, whether that is at all a reasonable requirement.
Lordship.
Requirement may be many,
Many.
but whether that comes under reasonable requirement, whether that point can be considered or not in view of these two grounds
The
formulated.
first ground is wide enough, Lord, to include that.
Yes. Thereafter, the question of second.
That, Lord, I will
You
come.
see,
The
what you
second
see,
one.
as because it is a flat, 99%, there cannot be any partial eviction, as because it is a flat.
Lord, so far as, Lord,
A residential flat, the right to privacy is there. So 99%, this number 2 cannot be granted.
but in this context, Lord, all that I say is that your lordship will find that the question of partial eviction has to be gone into by the first appellate court. It is a statutory mandate on a court. Therefore, Lord, whether it is
Right, but-
feasible or not,
but from the
or
facts of the
infeasible,
case- from the facts of the case, whether it would be feasible or not.
that,
Had
for
it
that
been a-
reason,
had it- from the commissioner's report, whether it
yes.
would be feasible or not.
Yes, that is one. Secondly, whether, Lord, your lordship as a second appellate court will consider, or it is, Lord, for the court which passed the degree has to consider that. Because, Lord, the statute says that the court which passes a degree has to consider the aspect of, Lord, partial eviction. That having not done so,
Because from
Well,
the
the first
commissioner's
appellate
report,
court-
I think that can be gone into by the second appellate court.
but
Whether this-
ideally it should have been gone by the first appellate court who had passed the degree. So if that is a statutory mandate on the court who passes the degree.
had it been a trial court, then definitely you see that partial eviction, when it is a case of flat, residential flat,
Lordship.
that is very not feasible.
But in this particular case, Lord, I can show your lordship whether it is possible or not. But even if, Lord, if I go by, Lord, the first ground, I can show before your lordship that, Lord, their requirement is, Lord, inflated, and they do not really have a requirement of the nature that they're
That's it.
speaking
That
about.
means the suit will go.
That
on
is
the
a-
question of
yes.
partial eviction.
And, Lord, on the second aspect, my argument will be, Lord, that it was for the first appellate court, Lord, to consider before passing a degree, according to, Lord, the provision of the statute, to consider whether, Lord, the requirement, when it comes that the requirement is there of the plaintiff, can be met by partial eviction. So it is, in fact, Lord, not for the second appellate court to consider, it is for the first court who passes a degree has to consider that.
Anyway, that is also a point for consideration.
Yes, because your lordship is third court here, and not just not
Have to
your lordship is
consider on these two
examining the
particular
propriety of
points,
yours.
1 and 2.
Lordship.
And whatever is relevant for consideration, that I have to go through.
And even if your lordship finds that there are other grounds to be incorporated, that your lordship can do so under section 100 subsection 5 of the Civil Procedure Code. The lordship can also add grounds if your lordship finds in course of hearing that other substantial questions of law are involved here.
So today it is 3:30.
Yes, Lord, I come back on the next day.
Come back on the next day.
চারটের পর
Yes. Learned advocates for the parties are present. Mr. Mukherjee commences his submission but could not conclude the same. Let this matter appear for further hearing. Month of December, this week it cannot be taken up. Month of December.
5th of December at 2 p.m.
5th of December. 5th, actually Friday I usually take part hard and assign matters. Some original side
I'm
matters.
free. I'm free.
अच्छा ये
It's free every day.
1 तारीखे
4th or 3rd, any of them.
My lord pleases to fix any date and time, my lord.
2 o'clock.
But any day, because your lordship is hearing, there would be continuity. So any day, really would not take much of your lordship's time. Because this is on a very small issue.
আর ইয়েতে দেখুন তো 2 তারিখে 3 তারিখে
2 p.m. would be, my lord.
3 তারিখে 3 Yes, when shall I keep it? First, second or third? But whatever it is, it will be at 2 p.m.
2 p.m. my lord. Any
No,
day.
whenever.
তারিখে 2 আর 3 দুটোতেই দুটোর সময় ফিক্স আছে 3 তারিখে 2 p.m. আছে 3 p.m. আর 2 তারিখে 2 p.m. নেই। Okay, I'm keeping it on 2nd of December.
2 p.m.
Oh, 2 তারিখেও 2 p.m. আর 3 p.m. আছে? আর ও 2 তারিখে 2 p.m. আছে। আচ্ছা,
At 2 p.m. any day.
I'm keeping it at 3 p.m. on 2nd. Let this matter appear on 2/12/2025.
Second day I have come some
Second day
difference.
of some
Second and
problem.
third, my lord, I have had
এই 4 তারিখে
matters
দেখুন
fixed.
তো, দুটোর সময় কি 3টের সময় করা যাবে কি?
ছয় তো শনিবার
Only my lord visiting at 2 p.m. would be better. That is all what I think. So any day otherwise convenient to your lordship.
but 8th or 9th or lord
8th
4 তারিখে
8th
4 তারিখে কিছু নেই। Shall I keep it on 4th or 8th you want?
but maybe on 8th or 9th whenever lord
This let this matter
একদিন
appear on 9/12/2025
ঠিক আছে তো
at 2 p.m.
2 p.m. will give me some lord time from lord making
Because
a
3 p.m. we don't know whether it will
yes,
be
yes at least 1.5 hour or 2.5 hours
9th at 2 p.m. right?
I'm grateful.
obligation online
item. Okay, come tomorrow, mention tomorrow.
but the two paper books have been lord filed today lord the compilation of papers I must say one compilation of papers
The compilation filed by the learned advocate for the appellant be kept with the record.
lordship fix আছে আমি কি করব
রোজ ফ্রি মিস্টার মুখার্জি রোজ ফ্রি যবে বলবি তবে চলে আসবে ভাবলাম দুটো থেকে বল আমার সাইড বদলে নিতে লজ্জা করে না